some lemons, but my Jesus, he been making lemonade. He been making lemonade. I'm chilling in the shade. Life gave me some lemons, but my Jesus, he been made it with that living water. Spirit, Son, Holy Father. Devil thought he really got us. I guess he just forgot that God works everything for better, no matter what the weather. He knits it all together, cozier than a sweater. Oh, you're lighter than a feather. Just think about the things you've done. You mix the sour with the sweet, and that's a perfect remedy. The love of God has got me clean, no old spice. That desert I was in was deep, so dry, but now I'm out here feeling free, so fly. I'm chilling in the shade. Life gave me some lemons, but my Jesus, he be making lemonade. My Jesus making lemonade. I'll watch my worries wash away. It's gonna be okay. Life gave me some lemons, but my Jesus, he be making lemonade. Sweet like sugar cane on a summer day. Ain't my Jesus better than the words I could ever say? Promise that the great, the good, the bad will come along. Cause if life is always easy, probably doing something wrong. Okay. He comforts in the sorrow, he's giving in the loss. He stole the shame I carried, he worried on the cross, providing me a future, I'm running for today. Life trying to give me lemons, but my Jesus making lemonade. My Jesus making lemonade. I'll watch my worries wash away. It's gonna be okay. Life gave me some lemons, but my Jesus, he be making lemonade.
So rolls a riot van and sparks excitement in the boys. But the policemen look annoyed. Perhaps these are ones they should avoid. Got a chase last night from men with truncheons dressed in hats. They didn't do that much wrong, still ran away though for the laugh, just for the laugh. And please just stop talking, cause they won't find us if you do. Oh, those silly boys in blue, well, they won't catch me and you. Have you been drinking, son? You don't look old enough to me. I'm sorry, officer, is there a certain age you're supposed to be? Cause nobody told me. And up rolls the riot van, and these lads just wind the coppers up. They ask why they don't catch proper crooks. They get their address and their names took, but they couldn't care less. Thrown in the riot van, all the coppers kicked him in, and there was no way he could win. Just had to take it on the chin.
Good morning. Hello. My name is Grant Smith Ellis. What a night. What a morning. That was a long night. This is Towel News. If you were with us till midnight, or whatever it was, that was a hell of a night. A lot of bombs were dropping. America was hit. The 5th Naval Fleet in Bahrain was hit. Then our air bases in Kuwait were hit. Well, we bombed first, to be fair. We absolutely lit Iran up. We hit them like 200 times. Mr. President was a little mad. And then, this morning, Iran hit us again. Well, we probably hit that. Well, we hit them again first, actually. In Bandar Abbas. We destroyed their maritime shipping control tower. It kind of looks like an airport control tower, but it's over the Strait of Hormuz. We blew it up. Yeah, we were made. So, that was a long night. And then, hello, chat mom Lynn, it's okay to see you. Good afternoon. Don't mess with Alessi. So I didn't have time to review any court filings last night because the bombs were falling in Kuwait, in Bahrain, in Iran. Now the bombs are falling again. I'm just going to hope that, these are what our friend Silent Dogs would call bombs of peace, missiles of peace, and it doesn't get worse, because I'd like to read some court motions. But when the damn Iranians get all made, and when we get all made, I can't really read court motions because the bombs start falling. So, yeah, picking up where we left off. And I will show you some footage. If you listen about the court document, I will tell you what's going on with the war. But people need to know about this motion to dismiss. And then we will talk about the war. I know, priorities, right? Some people are like, but Grant, I want to hear about the court motion. And I'm like, well, what about the war? And they're like, Grant, I like court motions. Now listen, so do I. But, sometimes we got to balance that duty out in the public interest. Today, we can do a court motion for at least an hour or two, barring some catastrophe that happens. All right, let's do it. And then we'll see each other tomorrow afternoon. I'll see if I can get down to Plymouth. Probably going to watch it virtually. There's also a World Cup game tomorrow, like during Karen's hearing, but that's not related to this motion that we're going to read. There's 4 civil cases arising from the January 29th, 2022 death of Boston police officer John O'Keefe. Okay, Karen Reed, his then girlfriend, was tried and acquitted in June of 2025 for his death in criminal court. Okay, now there's 4 civil lawsuits. The first one was filed by John's family against 2 bars in Kennington and also against Karen. That's in Plymouth Superior Court. That's the one everybody talks about. There's a lot of Proctorgate nonsense going on that docket. Then there was another lawsuit filed by what we call the H.A.M defendants, or the H.A.M plaintiffs, depending on your perspective. That's the Higgins, Albert, and McCabe people. All right, they're a combination of rich defense contractors and undercover ATF agents and Boston police officers. I know, when you put it like that, this case makes a lot more sense. So anyway, William Swift, of course you can. Everyone is equal. All a wrench really does is prevent people from censoring you. So, have fun. And also, Nightbot can't ban you. But Nightbot can yell at you, even with a wrench. Now, welcome to the channel. Now, let me continue. So, that case, it is filed originally in Barnstable Superior Court. It's like a tort claims, not a Tort Claims Act. It's like a Massachusetts Fair Trade Practices Act claim. And then some other stuff. I'm not really exactly sure. We're going to learn more about it. I think part of it's defamation. It had something to do with unfair trade practices by Karen, who doesn't really sell anything, and she's not really a manufacturer, so I'm a little bit confused about that. But anyway, and then there's this journalist, Aidan Turtleboy Carney. Now, Aidan Turtleboy Carney has been writing about corruption in the state police forever. And in 2022, September or so after John O'Keefe's death, but before Aidan was covering Karen's case, which started in the spring of 2023, Aidan Carney wrote about this Norfolk County State Police Detectives Unit that investigated Karen and that investigated Sandra Birchmore's death and covered that up. That's another case you want to look into involving Matthew Farwell. He's a bad man. And then this unit, Aidan figured out, also put false criminal charges in 2014 on this woman named Tiffany Overstreet to help a man named Robert Devine, who was also grooming Sandra Birchmore. And you might be saying, okay, so what happened then? Well, by the spring of 2023, Aidan Carney and Karen Reed linked up. However, I think the people that linked them up were actually working as undercover private intelligence operatives for the state and also these very wealthy witnesses. And in turn, they just caused chaos in Karen and Aidan's life for years. Okay? And they made Karen, they tried to both keep Aidan and Karen close to each other. This journalist and this criminal defendant. And also divide and conquer them, and also ruin their movements, and also plant moles around them, and also launder evidence to use against them in future civil proceedings. It was very methodical and very well funded. Almost like somebody had millions of dollars to fund this damn thing. So anyway, by the time that Karen gets acquitted, 3 or 6 months later, these people the H.A.M defendants or plaintiffs or whatever you want to call it, file a lawsuit against Karen and Aiden in Barnstable Superior Court. That lawsuit is moved by the trial court to Plymouth Superior Court to be heard by the same judge that is hearing the O'Keefe family lawsuit against Karen and the Boz. All right? And that's Judge Gilday. Everybody knows Judge Gilday. He trends on X all the time now. Judge Gilday tried so hard not to trend on X that he worked himself into a shoot and trended on X. Okay? That's what happens in the modern world. All right? Now, anyway, let's continue. There's also 2 other civil cases. One, Karen filed in Bristol Superior Court against the state police and the Canton police for negligently hiring and retaining Michael Proctor, one of the police officers on the state police detective unit, and who was supervised by Brian Tully, John Fanning, and Yuri Buchanan, respectively. Okay, Brian Tully was the detective lieutenant. John Fanning was the first officer. Fanning wrote the report clearing Farwell for Sandra Birchmore's murder. Important to remember that. And Yuri Buchanan, although we agree on Ukraine, apparently. He blocked me on Twitter. I'm all mad. Yuri Buchanan was the sergeant. Now, Buchanan and Fanning used to work in Stoughton, all right, with Robert Devine, okay? And I don't know if Farwell was at the department at the time, probably, but probably with Matthew Farwell as well, before they went to MSP. Now, Karen sued MSP and the town of Canton, okay, because they knew or should have known about Michael Proctor's horrific, 12 years of racist text messages and sexist and bigoted. Basically, Michael Proctor hates everybody, even the Irish. I'm pretty sure the only people he doesn't hate are white Anglo-Saxon Protestants who have been around Massachusetts since the Salem witch trials. You know, I don't know how the hell that works. It certainly explains the voodoo dolls, though. Don't even get me started on the voodoo dolls. So anyway, there's that case, okay? Then there was another case that Karen filed against the H.A.M defendants, okay, and Michael Proctor, and Brian Tully, and Yuri Buchanan. Now that case was originally filed, I want to say in Bristol Superior Court, but then it got moved up to federal court in front of Chief Judge Casper. Now, in that case, the H.A.M defendants have filed a motion to dismiss, okay? As if this weren't confusing enough. But that's not what we're talking about today. This is Karen's motion to dismiss in the Plymouth Superior Court action that was originally filed in Barnstable by the H.A.M plaintiffs, who are also H.A.M defendants, that Karen is now moving to dismiss. Aiden has also filed a motion to dismiss. All right, now, I tried to tell you all, civil procedure is not the same as criminal procedure. Like, civil cases, it sounds like it's the same thing because it's in the same court. It's really not. It's so convoluted, and I think people are already starting to realize it. They're like, Grant, I saw some posts on Twitter, like, Grant, I'm gonna need you to interpret this 2 sentences of Judge Gilday's ruling, please. I have no idea what it means. Yeah, civil court is a little complex. But anyway, 30,000-foot elevation perspective. What are we talking about today? I think I've sufficiently prepped you to talk about this anti-SLAPP motion to dismiss. Well, what's the anti-SLAPP statute? Well, the anti-SLAPP statute is what it sounds like. An anti-strategic lawsuit against public participation statute. Now, what does this mean? Well, it means, now this is what's called a special motion to dismiss, which has implications, by the way. Discovery has now stopped in the defamation case. Okay? Discovery has stopped. Or the, whatever it is, Fair Trade Practices Act case. It's done. It is paused. Not permanently, but it's stopped. They are entitled to no discovery as soon as that motion hit the docket. Literally, it was yesterday, technically, but for our purposes, it didn't get published by the clerk till about 30 minutes ago. Discovery is done for now, in that case. As soon as you get this motion on the docket, discovery stops. Only in the H.A.M lawsuit against Karen and Aiden. They are entitled to no discovery while this motion is pending. Why? Because it's called a special motion to dismiss. Okay? A special motion to dismiss, you have regular motions to dismiss. For example, under 12b-6, Rule 12b-6, you can file, which is also under Twombly and Iqbal, complicated. You can file to dismiss for what's called failure to state a claim. Everybody gets one. That's where you argue that the plaintiffs failed to establish, based on the plausibility standard, a claim upon which relief can be granted. Okay? You don't have to make your whole case, but you gotta have enough there to meet a 12b6 motion to dismiss. But that's different than a special motion to dismiss. A special motion to dismiss under the anti-SLAPP statute stops all discovery, which a 12b6 does not do. And a special motion to dismiss is a special kind of argument. You're not saying the other party didn't have enough of a claim to argue a tort in law. A tort is someone had a duty, basically, I'm generalizing. Someone had a duty, they broke the duty, or like someone had a contract, they broke a contract, they caused damages to you, they were the proximate cause of the damages, and then also like you can define the damages, okay? That's a tort, all right? When you're doing a motion to dismiss, you're saying they didn't plead enough to make a tort, okay? It's different than a crime, where you got to prove like intent, like most of the time, mens rea, the mental status requirement, actus rea, the act requirement, okay? And you got to prove it beyond a reasonable doubt, okay? And you got to do the proximate cause analysis, okay? And you got to prove it beyond a reasonable doubt. In civil court, you're just alleging that someone had a duty, either by common law, like, don't do things that are dangerous. That's not a common law. I'm just using an example, like an unenumerated law, like just a common sense thing. Don't do dumb things. Or there was a statute that prescribed upon unto them a duty, and it's actually better when there's a statute. And you're arguing that a reasonably prudent person, most of the time, depending on if it's like you're trying to show negligence or recklessness or extreme recklessness, knew or should have known that what they were doing could breach a duty, pose a danger, etc., etc. So that's a 12b6. An anti-SLAPP motion to dismiss is different. It's special. You're saying to the court, Your Honor, we don't, setting aside the merits, and they will argue the merits, but setting aside the merits, taking all facts in the light most favorable to the moving party, well, to the plaintiff, actually. Even still, Your Honor, everything that they're alleging is nothing more, this would be the argument under the anti-SLAPP law, than my attempt to participate directly in the petitioning process of my government. Like I was either talking to a court or a cop or a government body, or I was petitioning the government, like literally saying to the government, I'm petitioning you for redress of my grievances. Like that, you say to, like, Judge, if we allowed this suit to go past this point right here, you would be in effect chilling my ability not to speak. It's not necessarily a First Amendment claim, because the First Amendment doesn't apply to private actors. It's you'd be chilling my ability to redress my government in any form for my grievances, because you're in essence turning it into a tort. You're turning my redress of my grievances with the investigation into Karen's death, with John's death, with the Karen is alive, obviously, with the police sort of tactics, with the prosecutorial tactics. Your Honor, if you say that my criticism, this is the argument, I'm not saying anyone's right, this is the argument. It's why it's different than a 12b6. You're saying, Your Honor, even if they're right, even if I did this, even if it's potentially a tort, Your Honor, I'm publicly participating in my defense, if you're Karen, because remember, Karen and Aiden are each doing a motion to dismiss. This is Karen's. You cannot, and we don't know what Karen's going to argue, I haven't read it yet, but the general premise is it's a special kind of motion where you assert that, Your Honor, if you allow this case to go forward, you would fundamentally threaten like key pathways for citizens to redress their grievances with their government. It's the First Amendment in a civil context. Does that make sense? My pleasure, pretty please, with sugar on top. What a wonderful username. They say, thank you so much for the thorough way you break everything down for us. I greatly appreciate your gift to explain everything and tie it all together. Ah, yes, well, James Joyce's Finnegan's Wake is my North Star. I like to tie it in with a little Hegelian sort of syntactical historical dialectic, and I like Gambetto Vico's recursi e recursi, and I like to kind of tuck everything neatly together in the end in a nice little bow, like a shoestring looping back unto itself. And that's what history is, after all, isn't it? So I try to present my explications in the Hegelian dialectical form so that the synthesis you obtain from the disparate information is a cohesive whole, and now allowing you to obtain sort of an overall 30,000-foot perspective while recognizing there are different arguments going to be made by both sides there, and allowing you to predict how the future of history itself is going to play out. Yeah, that's how my mind works. Anyway, we're talking court motions today, so let's get reading. British Reporter Towel is going to do this for us. Now, you might say, Grant, why do we have to do this with British Reporter Towel? Because, well, these motions are really, really, really long. Now, I understand someone probably submitted this a bunch of times, but it's 961 pages. And even if it's only like 25, I'm not reading all that. Now, I will pause. Good morning, Jazzy Mom, and good morning, Kim. It's so good to see you. And Danette, welcome to the channel. And hello, Helena. It's so good to see you. And I love sarcasm. What a great username. I too love sarcasm. And Deborah, it's so good to see you. And One Yummy. And Gen X, so good to see you as well. All right, so here we go. And I do think the fact that now that this motion is filed, it will play into the motion to compel that is trying to be filed against Aidan Carney in the case filed by John O'Keefe's family. But before we even get there, let's listen to Karen's motion, and I'll break in and say things as I feel relevant. Let's go.
Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Defendant Karen reads, special motion to dismiss pursuant to the anti-SLAPP law, GLC 231, Section 59H, AND motion to dismiss pursuant to Mass. RCIV. P. 12B6.
So it's a combined motion to dismiss under 12B6 and the anti-SLAPP statute, which is 231-59H.
P. 12B6.
Oh, well, that's true, Danielle, Sammy. I expect eventually we'll see an argument from Aidan that discovery should be stayed until at least the criminal case is done.
P. 12B6. Introduction. Karen Reed was charged and then prosecuted twice for the death of Boston police officer John O'Keefe, 3. The first criminal trial ended in a mistrial on July 1, 2024. The second trial, which commenced in April 2025, resulted in an acquittal. Her defense at trial was consistent, clear and supported by overwhelming circumstantial, medical and scientific evidence. She did not kill Mr. O'Keefe, and was framed by the conflicted and corrupt police investigators and the individuals in the house at 34 Fairview, who were involved in Mr. O'Keefe's death. Plaintiffs have now sued Ms. Reed for speech pertaining to her defense. The legislature, however, has enacted very broad protection for petitioning activities, like Ms. Reed's. Duracraft Corp. versus Holmes Prods. Corp. 427 Mass. 156, 162, 1998. The Anti-SLAPP Statute, GL Circa 231, Section 59H, provides civil immunity for the exercise of the right to petition the 1. Government. Its protection extends not only to statements made directly to government bodies, but those made in connection with ongoing judicial proceedings and statements reasonably likely to enlist public participation. GL Circa 231, Section 59H. The statute immunizes this broad category of conduct from suit, except where it is devoid of any reasonable factual support or any arguable basis in law. Bristol Asphalt Company versus Rochester Bituminous Prods, Inc., 493 Mass. 539, 550, 2024, Bristol Asphalt, quoting GL Circa 231, Section 59H. Here, and as explained below, the anti-SLAPP statute requires dismissal of all of plaintiffs' claims against Ms. Reed because they are based solely on her petitioning activity, and plaintiffs cannot prove by a preponderance of the evidence that her petitioning was devoid of any reasonable factual support or arguable basis in law. GL.
So this is British Reporter Towel, He's kind of a combination between Southern Maine and British Reporter Towel. So good to see you all. But yeah, he saves my voice. I overused my voice while covering the war, so it's good to have a little balance. And out of all the voices that I've found, British Reporter Towel is one of the best. But yes, just to break in, you must understand what Karen's lawyers are doing is called an IRAC, Issue, Rule, Application, Conclusion. We are now through the I part of that. What's the issue? The issue is Karen has this argument. She has a burden under the statute to prove that she has not made any arguments devoid of any reasonable factual support or arguable basis in law in order to assert the anti-SLAPP statute. Hello, Kevin from South Boston. I am a proper Southern Maine. All right, let's continue. But that's called the issue part of it. Then we're going to go into the rule, the application, the conclusion. It's going to be an interesting read. Hello, Bossy's Texas Chica Bella. We're learning about the anti-SLAPP statute. Hi, Bella. Bella's a cat. Bella's in the kitty CIA. She's on assignment. I have no further comment. She knows where Chloe the dog in a wig is, though.
GL circa 231, section 59H. Accordingly, Ms. Reed moves to dismiss the claims against her under the anti-SLAPP statute and pursuant to Mass. RCIV. P. 12B6.
So all the American voices, as much as I'd love to say, like, they're, enjoyable, no. The only one that even sounds somewhat human is the British one. We did a lot of testing. But yeah, I appreciate all the feedback. It's, this is actually an accessibility feature for people who are visually impaired. So they're always trying to improve it, but it doesn't sound fully human. It really helps me, though, and in particular my eyes as like a disabled person. I can take in a lot of text that would be hard for me to read because of these softwares, so I just get used to British Reporter Towel.
P. 12B6. Ms. Reed also seeks her attorney's fees pursuant to the statute. In support of her motion, Ms. Reed submits the affidavit of Karen Reed, the Reed Aff, an affidavit of Damon M. Seligson, the Seligson Aff, including exhibits appended thereto. Factual background. Unlike a motion to dismiss for failure to state a claim under Mass. RCIV. P. 12B6A. Court faced with an anti-SLAPP motion shall consider. Supporting and opposing affidavits. Stating the facts upon which the liability or defense is based. GL circa 231, section 59H. Amato vs. Perlera, 99 Mass. App. Court 1125, Unpub. 2021. Considering exhibits submitted by the parties on anti-SLAPP motion. 1 here, Ms. Reed sets forth the following facts drawn from the 1. Each of the exhibits referred to in this motion, X__, is attached to the Seligson Aff. 2. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Allegations in plaintiff's amended complaint, the complaint, and the affidavits and exhibits. Filed herewith. At count 1 of their complaint, plaintiffs allege that Ms. Reed repeatedly publish, false statements asserting or reasonably understood as asserting that the plaintiffs were responsible for the murder of Mr. O'Keefe, and a cover-up of their purported role in that murder. Complaint paragraph mark 147. Plaintiffs do not identify the allegedly defamatory statements in count 1, but the complaint only identifies a handful of allegedly false statements by Ms. Reed about plaintiffs, stating to investigating officers prior to her arraignment that Brian and Colin Albert beat up Mr. O'Keefe, see id. Paragraph mark 19, which statement was released to the public during a judicial hearing in April 2024, see id. Paragraph mark 21. Stating in a discovery motion during her first prosecution that Brian and Colin Albert were responsible for Mr. O'Keefe's death and that Ms. McCabe was the mastermind who covered it up. See id. Paragraph mark 27. Forwarding the motion to defendant Aidan Kearney, who then published it. See id. Paragraph mark 32, 37, 38. Telling Mr. Kearney, through an intermediary, that Brian, Nicole, Chris, and Julie Albert all testified to a grand jury that Colin Albert was present at the Alberts' home at 34 Fairview. See id. Paragraph mark 49. Telling reporters during her second trial that Ms. McCabe's testimony at the trial was perjured and that she was lying. See id. Paragraph mark 120. telling a podcast on January 12, 2026 that Mr. O'Keefe entered the Alberts house, and much sooner than later met his demise, and that someone in that house killed John O'Keefe. See id. Paragraph mark 130. As described below, all these statements constitute petitioning activity. Similarly, at counts 3, 4, 6, 7, 9 and 10, plaintiffs assert various non-defamation claims against Ms. Reed. Specifically, counts 3, 6 and 9 allege that Ms. Reed is liable for aiding and abetting 3 discrete torts allegedly committed by Mr. Kearney. 3. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Defamation, intentional infliction of emotional distress, and negligent infliction of emotional distress. They all allege the same activity, that Ms. Reed, continuously and intentionally, provided defendant Mr. Kearney with non-public and or confidential information about her. Criminal case. Complaint paragraph mark 170, 193, 209. Counts 5 and 9 allege intentional and negligent infliction of emotional distress, based on Ms. Reed's alleged campaign of false and outrageous statements about plaintiff. Complaint paragraph mark 173, see also id. Paragraph mark 196, NIED count based on Reed's campaign of outrageous, cruel, and malicious lies. The emotional distress claims appear to be based on the same statements and conduct underlying the direct defamation count and the aiding and abetting counts. Plaintiff's final claim against Ms. Reed, count 13, alleges a civil conspiracy between Ms. Reed and Mr. Kearney, an agreement. To defame the plaintiffs and to inflict severe emotional distress on them. Complaint paragraph mark 213. For the reasons set forth below, these counts should be dismissed pursuant to the anti-SLAPP statute because they are based on the same statements that underlie count 1, all of which fall under broad definition of petitioning activity in the anti-SLAPP statute. Argument I. The Massachusetts Anti-SLAPP Statute. The Massachusetts Anti-SLAPP Statute, GL Circa 231, Section 59H authorizes a defendant to file a special motion to dismiss when facing claims based on the defendant's exercise of her right of petition. See Bristol Asphalt Company, 493 Mass. At 548 to 49. The statute's powerful procedural protections aim to foster the speedy dismissal of claims based on petitioning unless it was devoid of any reasonable factual support or any arguable basis in law. Id. At 557, quoting GL Circa 231, Section 59H.
Yep.
4.
Pause. So we had a question from Kevin from South Boston. If I would explain this as we get through it, or once we're done, yes. Now, I know for some of you it's going to be a little confusing, so I want you to write 4 letters down. Okay, T.A. Sarah is not here, but yeah, I agree. Bossy Texas chick. I blame Robert Devine. But yeah, I want you all to write this down. This will be on the final. T.A. Sarah will be checking. I want you to write 4 letters on your pad or whatever you're writing down, your notepad, your, whatever you have with you, your legal pad. If you have a pen, that's great. Pencils will do. Your phone will work. Okay. Iraq. Okay. I is the first letter. Okay. That Kevin from South Boston. We're gonna go slow. Okay. Then an R. Okay. Then an A. Then a C. Now write them top to bottom. I-R-A-C. Iraq. Okay. Now, whenever we're reading a legal motion, the 4 big words we want to keep in mind are issue, rule, application or argument, same thing, and then conclusion. You always want to know, what is the lawyer doing? Is the lawyer telling the judge what the legal issue is? Is the lawyer explaining the legal issue, the rule, or is the lawyer applying the facts of the case to the legal rule? Now, here, the lawyer for Karen has already set up the standard. We're talking about the anti-SLAPP statute and Karen's burdens under said statute in the case law. Now, he's got to neatly take the facts of the case that he also sort of previewed and tie them into why they support Karen's argument for dismissal under the anti-SLAPP statute. And that's the next part of the document. So that's how you got to sort of read it. It's going to say the same thing a few times, but it's not what is the document saying, it's what's the point. You're going to hear him say over and over, this is what the anti-SLAPP statute requires, this is the standard, this is the fact. What you're looking for is, and thus, Karen should win her motion. All right, so we got to wait for it to be all tied up, but that's how to listen and read a legal motion. We're about to get into the argument section. This will be the longest and meatiest section of the motion. And then after the argument is done, they'll sum it up in a quick conclusion paragraph, and then I'll explain it to you. But yeah, if you understood the first two paragraphs to just be the lawyer explaining the law to the judge, then you're in a good place. We haven't really got past that, but that is a crucial foundation. Issue, rule, now take the facts and apply them to what you just explained. And issue is just a narrow way of interpreting what part of the rule you're arguing about. Okay? So it's a lot of saying the same thing over and over and over and over again. All right, here we go. Next page.
The SJC has adopted a two-stage inquiry when evaluating a special motion to dismiss. Under the first stage, the movant must make a threshold showing through pleadings and affidavits that the claims against are based on the movant's petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities. Id. At 556. If the movant carries its threshold burden, the second stage of the analysis requires dismissal unless the non-move-on can prove a negative that the movant's petitioning activity, 1, was devoid of any reasonable factual support or any arguable basis in the law, and 2, caused actual injury to the non-move-on. Id. At 557. The non-movant's second stage burden is a difficult task. Id. The non-move-on must establish the lack of any reasonable factual support for the petitioning activity by a preponderance of the evidence. Id. Furthermore, in the case of conflicting affidavit testimony, the reviewing court cannot resolve disputed credibility issues in favor of the non-move-on. See Id. At 558. Thus, the evidentiary support in favor of the special motion proponent's petitioning activity must be quite limited to satisfy the non-movant's burden and avoid dismissal. See Id. Further, the anti-SLAPP statute provides that if a court grants a special motion to dismiss, it shall award the moving party costs and reasonable attorney's fees, including those incurred for the special motion.
All right, so does everyone understand what this is saying? Okay, the movant. It's does everyone know what a burden shifting exercise is? Oh goodness, oh goodness, oh I didn't think we were going to have to talk about the Fair Housing Act by corollary. All right. I'm not a lawyer. This is not legal advice, but I did go to law school. Okay, now everyone take a listen. I'd be cold calling on you right now. Burden shifting is the concept of when you are a lawyer, when the lawyer says the word, it's the movant's burden or it's the non-movant's burden. What the lawyer's talking about is you are the one who has to prove something. You know, like prove beyond a reasonable doubt in criminal court or in civil court now. It's not only with the state. And it's actually not always only with the state, depending on what you're doing in a criminal case. But it's way more often with the burden is often with the state in a criminal case. In a civil case, you can have burdens flying all over the place in the same motion. You can have it shift in one motion from one party to the other. That is called burden shifting. Now, here we have an example of burden shifting, where Karen's lawyer is saying, listen, judge, under the anti-SLAPP statute, the movant, who is Karen, has a burden. If Karen can make a threshold, not like a finding of fact all the way to reasonable doubt or even preponderance, it might be preponderance, I don't know what the burden is, make a threshold showing, let's see, proven negative, okay. So it's actually a double burden shift. It's not a reverse burden shift, it's a double burden shift. This is really interesting. I didn't know this. Oh, I'm learning something. I love learning things. Okay. Hello, Devon. Good morning. It's nice to see you. Okay, so here's how this works. Under the first stage, of the anti-SLAPP rule. Karen has to show through a threshold, like pleading and affidavit, which she's doing right now, that the lawsuit filed against her is based on the movements, so Karen's petitioning activities alone. So I was right. Only her petitioning activities. You get what I'm saying? All right? And, so it's a two-part thing. She's got to do that, and she's got to show that the claims against Karen have no substantial basis other than or in addition to Karen's petitioning activities. Okay? Broadly defined, as we know from the prior part of the ruling. If Karen meets her threshold burden, the second stage of the test requires dismissal unless, and this is where the first burden shift occurs, unless the other party, so here we're talking about the H.A.M plaintiffs in this case, the people who sued Karen and Aiden, can prove a negative, and that's a quote. And that's from the case that they've been citing, the standard on this petitioning, this anti-SLAPP law. So if Karen meets her threshold burden, if the court finds that she does, then it shifts over to the plaintiffs, the people suing Karen. They have to prove, okay, that Karen's petitioning activity, this is all in the same motion, was one, devoid of any reasonable factual support or any arguable basis in the law, and two, caused actual injury to the non-movement. So to the plaintiff, because remember, the movement here is of the anti-SLAPP motion. I know. Don't you love legalese? Isn't it great? No, it's not great at all. Now, here is where we're moving on to Karen's lawyer explaining the non-movement, okay, who is the non-movement of the anti-SLAPP. So here, the H.A.M plaintiffs, okay, their burden. Remember, Karen files the anti-SLAPP motion, but the way the law works is you can burden shift to the other party if you meet your threshold burden under the statute. And then they have to defend against your argument that the case should be dismissed, and they then have to meet a burden to survive your motion to dismiss. Everyone on the same page? Hashtag burden shifting. Oh, Half Shaft they sent a Cash App. Thank you so much for letting me know. I don't always get the phone. It's not my phone. I think it's how it does like data saving. I don't always get the notifications. However, if you ever like send one and want me to answer your question, please try to let me know in chat. I will look down. But it's just my phone doesn't do the little sound. It should. I don't know why it doesn't. Anyway, thank you so much for the question, Half Shaft, and welcome to the channel. Half Shaft says, for the love, TNN, how do I get unblocked from X? Oh, that's so funny. So one, you never have to send a donation to get unblocked from X. Your best bet is to just let me know your X username. So whatever your X username is, if you drop that in the chat, the @ symbol, I'll go unblock you right now. We'll do a hashtag live unblock. What a great moment. Historical serendipity of the highest order. If you want to be unblocked, though, please, you don't have to send a donation. That's never a requirement, my goodness. Just reach out to someone you see interacting with me. Either like Glamasuze has been very kind and helped in the past, and I forget who else. There are people who will just be like, hey, could you unblock my friend? And then I'll be like, yeah, it was a vestige of a prior era epic. I'm sorry about that. Then I unblock them. Okay? So that's how we do it. So you just let me know, Half Shaft, what your X username is in the comments here of the YouTube, and I'll unblock you right now. Thank you very much for your kind support of Tao Channel. Reese is like, I'm so glad Towel never blocked me. Yeah. Oh, Towel Mom Lynn has started a membership parade, ladies and gentlemen. Oh, goodness. If your name is, allegedly DB, or Kevin from South Boston, or Risa B. Oh, Risa, how wonderful is that? Or Chloe's mom, 412, or another normal mom. Listen, you all, first of all, Kevin from South Boston's going to lose it. Allegedly, B is going to have a great morning. Risa, excellent time to make a comment. You just got towel memberships. Chloe's mom's going to love it, and another normal mom's going to have a great morning. You didn't just get memberships. You got them from the one and only Towel Chat Mom, Lynn. Now, she loves penguins, okay? So, she wants to move to Greenland. She wants to start, a penguin, sanctuary. If you would like to say thank you, there is nothing you can do so much there's nothing you can do that will make her quite as happy as posting penguin emojis in the chat. Oh, Towel Mom Bunny and Kofi are here. Hi, Kofi. Hi, Bo. Kofi's a dog. I talk to Kofi sometimes. The man on the TV. He knows his friend on the TV. I'm Kofi. No, he's Kofi. I'm Towel. And Kofi probably got very confused. He was like, wait a minute. I'm Kofi. So anyway, if you want to make Towel Chat Mom Lynn very happy, thank you so much for your support and all of your compassion and just being a wonderful human. Towel Chat Mom Lynn. Towel Chat Mom Lynn is so wonderful, really. I definitely feel like I have a lot of support and love around me. I didn't feel that for a long time, and so many of you are the reason. Towel Chat Mom Bunny and Kofi and Bo and Towel Chat Mom Lynn and all of you. You're all wonderful. And hi, Towel Girlfriend, if she's out there. I love you and you're wonderful too. You're all just great. Oh, it's raining penguins in the chat. Towel Mom Lynn is going to have the greatest day ever. Now, that was your little mental decompression break. I did promise Half Shaft that I would do this. So let me go over to my Twitter. Alright? Let me just go over to the Twitter and do this live. Alright? Now we'll get back to our fun anti-slap motions. There's nothing as fun for me. I know it's very important because covering the war helps people get like a heads up about bad things that are going to happen, and it helps them stay safe. But it's really hard for little Tao. It is. It's hard. Oh, all right. Who's ready for this, ladies and gentlemen? Who's ready for this moment? Half Shaft, you're going to experience a legendary moment. There you go. Unblocked and followed. Good, Half Shaft. You have been unblocked. You are officially unblocked, and you do not have to send a donation to do that. But thank you all. And thank you for bringing that to my attention. God bless you all, you wonderful. All right. And shout out Towel Chat Mom Lynn. It's raining penguins. Listen, I understand some people love the song It's Raining Men. It's a fine song. Pete Bunny Towel doesn't like it. But Towel Chat Mom's Lynn song is going to be It's Raining Penguins. Hashtag It's Raining Penguins. All right, let's go back to the motion. Karen probably watches this sometimes, and she's like, what? And she's like, this is who the other countries watch for news about the war. Yeah, don't fight me, please. All right, let's continue. Go ahead, British reporter Towel.
GL circa 231, section 59H. Moreover, the award of attorneys' fees is mandatory. H.A.M. Expositions Company Limited, Bishop vs. Corcoran, 452 Mass. 852, 872. 2009, internal quotations omitted. Here, Ms. Reed easily meets her burden of establishing that all of the alleged activity is protected petitioning, and plaintiff cannot meet their burden to establish that her petitioning activity was devoid of any reasonable factual support or any arguable basis in the law. As a 5. Date filed the 7th. Result, the court should allow Ms. Reed's motion and award reasonable attorney's fees and costs. 2. The court should dismiss plaintiff's claims against Ms. Reed pursuant to the Anti-SLAPP statute. A. First stage, plaintiff's claims are based solely on petitioning activity. At the first stage of the anti-SLAPP analysis, a court need only conduct a facial review of a special motion opponent's pleading to identify which factual allegations serve as the basis for a particular claim. Bristol Asphalt, 493 Mass. At 561. However, the court can consult documents in the anti-SLAPP record to determine whether these factual allegations fall within the statutory definition of petitioning activity. Id. N.21. The anti-SLAPP statutes defines petitioning expansively. Id.
British reporter Towel, do you need a break?
See also. Duracraft Corp. versus Holmes Prods. Corp. 427 Mass.
What's going on, British Reporter Towel? Also, that was an epic super chat combo. Listen, you don't see a super chat combo every day. And I will tell you, ladies and gentlemen, Squirrel and... Hold on. I just want to finish.
156, 162, 1998, statutory definition of.
Now you're ready, British Reporter Towel. Just as I'm
Petitioning
talking about
activity
the
is very
combo.
broad. Indeed, the definition of a party's exercise of its right of.
All right. I wanted you to pause. I just wanted to say thank you for that super
Petition
chat combo.
in the anti-slap statute is very broad and includes several elements that swear.
How dare you, British Reporter Towel? I'm trying to say thank you for the super chat combo. Would you mind? How dare you? How dare you? Thank you, British Reporter Towel. So I just wanted to reiterate my thanks for that epic super chat combo from Jackson Unleashed and Squirrel. Very rarely do you see a super chat combo, 2 super chats literally back to back in chat. I mean, the odds are astronomical. God bless both of you, and shout out to Squirrel and Jackson's Unleashed. I like both your usernames, but Squirrel's username just makes my heart a flutter. So God bless you both. Thank you for being you, and thank you for your support of Towel Chain. Take it away, British Reporter
Apply to
Towel.
Moose Reed's speech and
British Reporter
date
Towel.
filed the 7th of July 2026, 4:48 p.m.
British Reporter Towel.
Superior Court, Plymouth.
British Reporter Towel, you're really bothering me today. You know, you and I are just not getting along. What are we on? Page, 5 at the bottom. British Reporter Towel and I are getting into a little bit of an argument. I feel like he's going on strike like the nurses. You know what I'm saying? Alright. Here we go. Let's begin. Try again, please.
The anti-slap statutes defines petitioning expansively. Id. At 550, see also. Duracraft Corp. versus Holmes Prods. Corp. 427 Mass. 156, 162, 1998, statutory definition of. Petitioning activity is very broad. Indeed, the definition of a party's exercise of its right of. Petition in the anti-slap statute is very broad and includes several elements that squarely apply to Moose Reed's speech and actions here, including any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body, any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, any statement reasonably likely to enlist public participation in an effort to effect such consideration, and any other statement falling within constitutional protection of the right to petition government. GL circa 231, section 59H. 2. Additionally. 2. The statutory definition is any written or oral statement made before or submitted to a legislative, executive, or judicial body, or any other governmental proceeding, any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other governmental proceeding, any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body. 6. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. In order to determine if statements are petitioning, courts consider them in the overall context in which they were made. H.A.M. Expositions Company. Limited. Bishop vs. Corcoran, 452 Mass. 852, 862, 2009. A facial review of the complaint shows the plaintiff's claims against Moose Reed are based on her statements, all of which meet the expansive and very broad definition of petitioning activity. 1. Count 1 is based on petitioning activity. At Count 1, plaintiffs allege that Moose Reed repeatedly publish, false statements, asserting or reasonably understood as asserting that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in that murder. Complaint paragraph mark 147. Plaintiffs do not identify the allegedly defamatory statements in count 1, however, in the complaint as a whole, plaintiffs identify a handful of allegedly false statements by Ms. Reed about plaintiffs, stating to investigating officers prior to her arraignment that Brian and Colin Albert beat up Mr. O'Keefe, see id. Paragraph mark 19, which statement was released to the public during a judicial hearing in April 2024, see id. Paragraph mark 21. Stating in a discovery motion during her first prosecution that Brian and Colin Albert were responsible for Mr. O'Keefe's death and that Ms. McCabe was the mastermind who covered it up. See id. Paragraph mark 27. Forwarding the court-filed motion to Mr. Kearney, who then published it. See id. Paragraph mark 32, 37, 38. Telling Mr. Kearney, through an intermediary, that Brian, Nicole, Chris, and Julie Albert all testified to a grand jury that Colin Albert was present at the Alberts' home at 34 Fairview. See id. Paragraph mark 49. Telling reporters during her second trial that Ms. McCabe's testimony at the trial was perjured and that she was lying. See id. Paragraph mark 120. Or any other governmental proceeding, any statement reasonably likely to enlist public participation in an effort to effect such consideration, or any other statement falling within constitutional protection of the right to petition government. GL circa 231, section 59A. 7. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Telling a podcast on January 12, 2026 that Mr. O'Keefe entered the Alberts' house, and much sooner than later met his demise, and that someone in that house killed John O'Keefe. See id. Paragraph mark 130. All of these statements by Ms. Reed constitute petitioning activity. First, the statement Ms. Reed made to investigating officers was after she had been arrested and was trying to convince the police officers that the Alberts, rather than her, were responsible for Mr. O'Keefe's death. See Reed Aff. Paragraph mark 8 to 9. Therefore, it was an oral statement made before an executive body reporting a violation of law by the Alberts and thus constitutes petitioning activity. See GL circa 231, section 59H, Town of Hanover versus New England. Regional Council of Carpenters, 467 Mass. 587, 592, 2014, reporting violation of law 2. Officials is petitioning activity, O'Gara versus St. Germain, 91 Mass. App. Court 490, 497, 2017. Second, the statements made in the discovery motion are similarly written. Statement, S, made before or submitted to a. Judicial body, CSMS Fin. V, LLC versus Conti, 68. Mass. App. Court 738, 746, 865 NE 2D 1142, 1149, 2007. Petitioning activities include statements submitted to a judicial body. Sharing the court-filed document is itself petitioning activity. See Wynne versus Craigle, 63 Mass.
Wow.
Court 246, 253 to 254, 2005, concluding that statements made to press that were essentially mirror images of statements made at disciplinary hearing were also petitioning activities.
This is
Ms.
great.
Reed did not have a commercial.
This is great research. Sorry. I paused my camera. It saves system RAM and it will make him read faster. Also, I just realized these are very long documents. This and the reply are at least 25 to 30 pages each. So maybe the reply is a little shorter. I'm going to order some lunch as we listen. Thank you for your patience. I'll be here. We'll be analyzing, but I'm going to need some food. I didn't know what I was getting myself into. You know, I should really think about that sometimes, but I'm like, I want to read a court document. So anyway, we're now getting into the meat of this, okay? We're learning all sorts of fascinating pieces of precedent, which I'm going to guess if we shepherdized and put in LexisNexis are all good law, as to the scope of modern case law related to petitioning activity. This, by the way, for the record, is what a anti-slap motion should look like.
Ms. Reed did not have a commercial motivation 3 when she shared the motion with Mr. Kearney. Instead, she hoped he would publicize it so that the public at large would understand that she had been framed and would pressure the Commonwealth to drop her prosecution and instead prosecute the true perpetrators. See Reed. Aff. Paragraph Mark 10. Compare Riverdale Mills Corp. versus Cavatorta H.A.M. Inc. 189 F sub. 3D. 317, 325, D. Mass. 2016. The complaint itself alleges that Ms. Reed's purpose in sharing. Notably, the complaint only alleges that Mr. Kearney, not Ms. Reed, acted in the course of trade and commerce and violated the Massachusetts Unfair Trade Practices Act. See complaint paragraph Mark 217 to 226. 3. 8. Date filed the 7th of July 2026 4:48 p.m. Superior Court, Plymouth. Docket number 2683 CV 00541. Information with Mr. Kearney was...
I did always think that was a little weird. Okay, I did always think it was weird that Karen's lawyer, or that the two things I thought were weird. One, that they kept filing lawsuits. I felt like this lawsuit was filed mostly to like they had to file this, even though it was probably not the best idea. I'm not a lawyer, this is not legal advice. They had to file this, or they would have looked bad. But what they did to themselves by filing this, I'm not sure this was the wisest idea. I'm really not. For a number of reasons. One, Karen raising money for a legal defense is not a commercial purpose. And they sued Karen and Aiden partially under a theory of like the Fair Trade Practices Act. What was Karen's commercial purpose? Commercial purpose, you might call it a legal defense purpose, but that's not commercial.
Information with Mr. Kearney was to widely disseminate the information to cast. Suspicion on the plaintiffs and away from Reed. See complaint paragraph Mark 48. The statements made in the discovery motion, shared with Mr. Kearney, were made to influence, inform, or at the very least, reach governmental bodies, either directly or indirectly. Blanchard vs. Stewart Carney Hospital, 477 Mass. 141, 149, 2017, quotation omitted. There is thus a plausible nexus between the statement and the governmental proceeding, id, and therefore they were made in connection with an issue under consideration or review by legislative, executive, or judicial body, or any other governmental proceeding, and were reasonably likely to enlist public participation in an effort to effect Ms. Reed's first prosecution and then her retrial. GL circa 231, section 59H. The same is also true of Ms. Reed's statements to reporters that Ms. McCabe had perjured herself during her trial testimony in Ms. Reed's second trial. Ms. Reed made the statements on the courthouse steps immediately after the conclusion of that day's proceedings. See Reed Aff. Paragraph Mark 10 to 12. The purpose was to widely disseminate to the public her defense to the prosecution that the McCabes, the Alberts, and Higgins were responsible for Mr. O'Keefe's death. See id. The goal was to galvanize public support and to pressure the Norfolk County District Attorney's Office to drop the prosecution or to refrain from a second retrial in the case of another mistrial. See id. Thus, the allegedly tortious statement is similar to the statements made to the Boston Globe in Blanchard vs. Stewart Carney Hospital, 477 Mass. 141, 148, 2017. In Blanchard, a hospital president made statements to the Boston Globe at the time the Commonwealth was considering revoking a hospital unit's operating license because of suspected abuse cases. The SJC held the president's statements were petitioning activity because the statement communicated to readers, likely including some of the licensing decision-makers. That 9. Date filed the 7th of July 2026 4:48 p.m. Superior Court, Plymouth. Docket number 2683 CV 00541. Progress was occurring at the hospital and that its license to operate the unit should not be revoked. 477 Mass. At 150. The statements were petitioning activity, made in connection with the ongoing licensure proceeding, because 1. They directly related to the Commonwealth's then pending investigation, 2. Was in furtherance of the objective of the hospital's petitioning. activity, the preservation of the hospital's license, 3, were issued in a manner that was likely to influence, or at the very least, reach, the Commonwealth because it was made in the widely circulated globe, and 4, the timing of the statements indicated a nexus with the investigation, because they were made while the investigation was pending. Additionally, the SJC has ruled that speech and advocacy designed to foment public participation around a pending judicial proceeding constitutes protected petitioning under GL Circa 231, Section 59H. See H.A.M. Risk, LLC vs. Voigtland, 476 Mass. 479, 481 to 486, 2017, holding the published article about a pending pollution lawsuit that included an implicit call for its readers to take action. Fits squarely within the second clause of GL Circa 231, Section 59H, any statement reasonably likely to enlist public participation. Similarly, here, Ms. Reed's statement to reporters that McCabe was untruthful directly related to the then pending prosecution, supported Ms. Reed's petitioning activity in that proceeding, to be acquitted, to have the claim dismissed, and to avoid a retrial in the case of a hung jury, was issued in a manner that would be widely reported, as it was covered by local television news channels, and was issued while the prosecution was still pending. The statement was thus petitioning activity. See id. Finally, Ms. Reed's statements in the January 2026 Rotten Mango podcast were also petitioning activity because they were made in connection with an issue under consideration or review by a judicial body, GL Circa 231, Section 59H.
Ron Mango has entered the
In
chat.
particular, even though the underlying 10. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683 CV 00541.
Just to be clear, she didn't actually enter the chat, but she's in the
Prosecutions had
court
ended.
filing.
Ms.
Nope,
Reed-
stop it. Stop it. Pause, British Reporter Tal, thank you. She's not actually
Date
in the
filed the
chat.
7th of July 2026, 4:48
British
p.m.
Reporter Tal, would you mind?
Superior Court, Plymouth.
People were asking why Karen did that interview, and it's because she has lawyers who were able to advise her that she could speak certain ways. And one of those things is being reflected in this. But Karen's very calculated. Her lawyers are clearly very smart. And you're seeing that play out right now. Alright, so where are we? We're at the top of page 11. Give me 1 second. British Reporter Towel is starting to get on my nerves. He's being a little rambunctious. You know, he's not necessarily following commands. He's got to listen. He's got to know what his job is. His job's to read things. And imagine if you had to read this all. I hope people who are going to read this, I give this as a very friendly warning to all the other channels, know what you're getting into. This is long. It takes a really long time, and save your voice. Alright? So, we are at the bottom. We're at the bottom of page 10, top of page 11. Alright, here we go. Go ahead, British Reporter Towel.
Prosecutions had ended. Ms. Reed was already defending a wrongful death claim brought by Mr. O'Keefe's family in Plymouth Superior Court, which had been filed in August 2024. See Reed. Aff. Paragraph mark 12 to 15. Ms. Reed's statements on the podcast were related to her case. They were intended to be widely publicized. 4. They were intended to keep her defense publicized. And 2. Persuade any judge or fact finder that she should not be held liable for Mr. O'Keefe's death, and they were intended to convince the O'Keefe family that it had sued the wrong party and should drop its suit. See Reed Aff. Paragraph mark 12 to 15. Thus, like her other statements with a plausible nexus to an ongoing proceeding, the overall context in which they were made shows that Ms. Reed's statements on Rotten Mango were made in connection with an issue under review by judicial body, and was reasonably likely to enlist public participation, and therefore constitute petitioning activity. H.A.M. Expositions Company Limited, Bishop, Supra, at 862, GL Circa 231, Section 59H. 2. The other, non-defamation counts are all based on Ms. Reed's statements that constitute petitioning activity. In counts 3, 4, 6, 7 and 9, plaintiffs assert various non-defamation claims against Ms. Reed. They should also be dismissed under the anti-SLAPP statute because they are based on the same statements that underlie count 1, all of which fall under broad definition of petitioning activity in the anti-SLAPP statute. A. The aiding and abetting counts 3, 7 and 11. Counts 3, 6 and 9 all allege aiding and abetting liability for 3 discrete torts allegedly committed by Mr. Kearney: defamation, intentional infliction of emotional distress, and negligent infliction of emotional distress. They all allege the same activity aided and. The Rotten Mango podcast has over 6 million subscribers at YouTube, making it one of the most widely distributed podcasts. See Read Af. Paragraph mark 14. See also weekly top podcast shows, YouTube charts, available at http URL 4. 11. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Abetted Mr. Kearney's tortious conduct, that Ms. Reed continuously and intentionally provided defendant Mr. Kearney with non-public and or confidential information about her criminal case. Complaint paragraph mark 170, 193, 209. The complaint's only allegations about Ms. Reed sharing non-public and or confidential information with Mr. Kearney are in paragraphs 28 and 49 to 51, all of which constitute petitioning activity. Paragraph 28 alleges that Ms. Reed forwarded her April 12, 2023 discovery motion, which had non-public documents attached to it. But, as discussed above, the discovery motion is a court pleading and thus a written statement s made before or submitted to a judicial body. In other words, it is petitioning activity. Paragraph 49 alleges that Ms. Reed falsely told Mr. Kearney through an intermediary that the Alberts provided grand jury testimony that Colin Albert was at the Alberts' house the night of Mr. O'Keefe's death. Paragraph 50 alleges that Ms. Reed told Mr. Kearney, not public, the feds have been involved longer than anyone is likely guessing. Paragraph 51 alleges that Mr. Kearney published an audio file capturing Ms. McCabe's 911 call the morning Mr. O'Keefe's body was found, and implies the file came from Ms. Reed or Ms. Reed's legal team. As with the allegedly defamatory statements made directly by Ms. Reed, all of these statements that plaintiffs say constitute aiding and abetting defamation were petitioning activities because they were made in connection with an issue under review by a judicial body, and reasonably likely to enlist public participation in an effort to effect such consideration. Like the alleged direct defamation underlying count 1, there is a plausible nexus between these statements and the prosecution. They were made while Ms. Reed was being prosecuted.
Oh snap! Somebody just got in trouble.
Being widely
Wait!
disseminated to support
British
Ms. Reed's
reporter
defense.
towel, wait!
See complaint paragraph mark 48, statements forwarded to Mr.
British reporter towel. How dare you? Somebody just got in trouble.
12. Date.
Look at this. Oh, somebody got in trouble. Ladies and gentlemen, we have to pause. My lunch is almost here too. We'll get back to this motion. Somebody just got in trouble. Somebody tell Cal. This motion, this order just went up on the docket. Oh, somebody's in serious trouble. On a scale of 1 to trouble, they're in trouble. You know, it's like a Taylor Swift song. They knew Tao was trouble when he walked in. Oh, goodness, somebody's in serious trouble. All right. Now, I know a lot of you the other day were a little bit confused about what this order was related to the motions to dismiss. At first, it looked like Karen's lawyers did something wrong. Oh, no. Oh, no. So, we're going to go to the initial order, okay? This new order just came down like 2 seconds ago. People are like, how do you all do this? Well, I just manually reload the mass courts docket and I look for things. So anyway, here is this order, okay, from Judge Gilday. Now, someone asked me on Twitter if I could interpolate this and kind of like make it understandable for the layman. That's what I'm going to do for you. First, I'm going to reset this because I got to make the cache a little better. All right, that'll make things load faster. Now, someone asked the other day, what does this order from Judge Gilday mean? It has to do with Karen's motions to dismiss. Now, to understand a motion to dismiss, the one we're reading now, you must understand what's called a 9A package. Okay, now, ooh, this is exciting. I get to teach you about 9A cover letters. Okay, so Karen filed a 9A cover letter with her motion to dismiss. Now, look at this. Oh, look how great this is. I love it. I love it. I love 9A. I love Rule 9A. Rule 9A is my favorite thing. Okay, so look at this. This is Karen's 9A filing. Now notice, it has her special motion to dismiss, okay? It has the affidavits, it has the plaintiff's opposition, and then it has the plaintiff, so that would be the H.A.M defendant's lawyer, Kiernan T. Murphy. It has his stuff, you know, and then it has a thing from Jen McCabe, and then a certificate of service. Karen has to write the original motion, send it to the other party, wait 10 days, get their opposition, determine if she wants to write a SIR reply, put it all together, and then file it herself. She has to file the other party's pleadings. Yep, it's called the Rule 9A package. Now, why is this relevant? Because it takes a long time to do this. You have to actually like liaise with the other side. You have to like try to meet and confer to narrow the scope of the issues, okay, that you're going to bring in front of the court on the motion. This is what this order's about. It doesn't explain it, but it's about the process by which the two sides went about compiling the 9A package for these documents. All right. Here's what it says, the initial order. Pleadings relative to the motions to dismiss scheduled for hearing next week were e-filed yesterday and today. This order was yesterday. That's the motion we're reading right now. And are under review by the clerk's office. They've now been docketed. Attorney Seligson, so that's Karen's lawyer, is ordered to email the clerk before 10 a.m. on July 9th, 2026. The Word document versions of Karen's special motion, judge just didn't want to convert him, I guess. And 2, an affidavit setting forth if there was any written or oral response to the June 25th, 2026, 1:43 p.m. and June 26th, 2026, 12:30 p.m. emails from Attorney Murphy to Attorney Rosenberg, Seligson, and Waters. If there were, a copy of any written response shall be attached to the affidavit, and any oral response shall be summarized in the affidavit. Okay, now you go over here, and it says, this was this morning, Attorney Seligson provided a response to my July 8, 2026 order. The response identifies a June 26, 2026, 12:31 p.m. email from Attorney Rosenberg to Attorney Murphy. Attorney Murphy is ordered to email the clerk before 4:30 today an affidavit stating forth the reasons such email was not included in the Exhibit B to his declaration of July 7, 2026. Oh, he got in trouble. Oh, he got caught. Oh, it's bad. It's really bad. I don't know what he did, but he got in trouble. He got caught. Oh, he's in serious trouble. It's bad. And we're going to have to write this up. Give me 1 second. And my food's almost here. Very untimely. Very untimely. So I got to go back to the first time I wrote this up. I also want to put it on the Towel News banner. It takes a little bit of extra time, but it's worth it. I like to be thorough and comprehensive, but that's a big deal. He's going to get all in trouble. You know what I'm saying? Uh-oh. Uh-oh. Why did a lawyer for the H.A.M parties in their ongoing civil case against Karen Reed and Aiden Turtleboy Carney represent to the court that Karen's lawyers didn't email him back during the Rule 9A process about Karen's anti-SLAPP motion to dismiss? Karen's lawyers did indeed email back Attorney Kiernan. Is that his name? What the hell's his name? Got a weird name. What is it over here? What's this dude's name? Kiernan, K-I-E-R-A-N. Kiernan T. Murphy. And now Judge Gilday wants to know why Attorney Murphy did not include that follow-up in his pleadings responding to Karen's anti-slap motion to dismiss. All right, everybody on the same page? Judge Gildea has just entered an order requiring that information be provided to the court before 4:30 p.m. Eastern today, July 9th, 2026. How about them apples? That's how you do it. You just got to be quick. Quick draw, towel, McGraw. All right, Chat Mom Lynn, it's a big deal. The motions that we're talking about right now, we haven't even got to the response. Karen, it appears that the H.A.M lawyers, okay, for the Higgins Albert McCabe, represented to the court in the response to this motion, okay, which we haven't read yet, that Karen's lawyers just didn't email him back during a key part of the conference regarding these motions under Superior Court Rule 9A and 9C. Then Judge Gildea issued an order yesterday being like, well, the H.A.M lawyers say you just didn't email them back. Mr. Seligson, prove to me that you did. Well, Mr. Seligson proved to Judge this morning that he did just that and did indeed email back the H.A.M lawyer. And now Judge has issued this order. Now, I don't actually see Attorney Seligson's response. All right. I only see the stuff in the 9A package. I don't see anything from Attorney... Oh, here we go. I got something from... What's this? Is this another... No, that's just the certificate of service. I don't actually see what Seligson filed. Okay, I'm just going to tell you. It's not on the docket. So I don't know what is in dispute. We're going to find out. Actually, you know what? We can find out by going to... What the hell do we have to go to? We have to go to Exhibit... We have to go to Exhibit B of Attorney Murphy's declaration from July 7th. All right. So here we go. This is Attorney Murphy, his declaration. Maybe we can find out what this is actually about. I'd like to go get my lunch, though. Okay. So, oh, we actually get to look at Exhibit B. That's nice. What is Exhibit B? Okay, no, that's not really what I want. I want Exhibit B. Just give me Exhibit B. What is it? What is it? I had a feeling it was a 9C conference. Alright, what is it? Alright, so it's this one. Hold on one second. Let me go back to Judge Gildea's order. A June 26, 2026 email at 12:31. From Attorney Rosenberg to Attorney Murphy. Rosenberg replied within 30 seconds to this? Wait, what is this about? Oh goodness, I have to read lawyers arguing over email. Alright, what are we yelling at each other about here, gentlemen? Is this the motion to dismiss? Alright, what do we got here? Seligson's like, here's the motion to dismiss. Okay, and then he... And then Murphy's like, we're going to request a default because you served a motion to dismiss an inoperable pleading. And we won't confer with you. And then Seligson's like, we assume your threat below refers to the fact that the caption is from the original case and that the citations are to paragraph and count numbers in the original complaint. We just discovered both facts after receiving your cryptic message. We'll serve you a corrected copy by the end of the day tomorrow, which will fix these errors, but it won't substantially change anything. Obviously, Ms. Reed has not failed to plead or otherwise defend as provided by these rules, and any filing or affidavit pursuant to Rule 55 stating otherwise would be blatantly and knowingly false. Murphy says, we've not made any threats. I'm simply putting you on notice of our intent to make a filing that we do not have any obligation to keep you apprised of. Your assumption is incorrect. If the issues with your submission last week were as simple as you described, we may have been amenable to your request that we accept a late motion. However, they are not. We take it from your response that your client does not wish to avail herself of our offer to conference and will proceed accordingly. Oh, this guy's being a jerk. Damon's like, we disagree, but let's schedule a call to discuss this. Can you talk today at 3? So that's June 23rd. And then later that day, Seligson follows up and memorializes by saying, Kiernan, Attorney Murphy, as we discussed this afternoon, attaches the motion to dismiss and special MTD with non-substantive changes that simply provide the correct case caption and citations to the correct paragraphs and counts in the first amended complaint. Also attached is an unsigned Word draft that shows the changes in red line. All right. And then Kiernan says, Aaron, my apologies. Wait, what? Okay, now do we go forward to a new day or something? No, now we're on the same day, and Aaron Rosenberg says the attached was also e-filed today as a follow-up. And that's at 5:05, and Seligson's email was at 4:06 Eastern. So then Chris Maddie follows up on the 23rd at 7 and says, Aaron, Mr. Rosenberg, my apologies for my lack of decent reception during our conference. I was attempting to respond to your comment that any affidavit submitted in support of a request for default would necessarily be false. I attempted to say and reiterate here that I'll write this up before I looked into it. You got to really know what you're looking at to understand this. Okay, so they're fighting right now. That was a little frame drop. They're fighting right now. First of all, the H.A.M lawyer's being ridiculous. Then he has to call in his boss, the big guy. He's now going to explain to Rosenberg why because Rosenberg captioned the file with the old case that got moved from one court to another without any substantive changes other than that, why he's gonna argue Karen actually defaulted by serving that, which is ridiculous. These lawyers hate each other. No wonder Judge Gilday is losing his mind. I attempted to say and reiterate here that our assessment of Ms. Reed's motion to dismiss is based on what we believe to be the only rational good faith reading of your motion, which is that it fails to plead or otherwise defend against the First Amendment complaint. I'm being gentle here, but is this guy a moron? Bro, I just graduated law school. I understand exactly what Seligson said. How are you saying that because he miscaptioned it, that somehow automatically renders the whole pleading void? That's not even that's just being a jerk for the sake of being a jerk. That said, we understand your position to be that your MTD's reference to the Barnstable action and the numbered paragraphs set forth in the original complaint were simply mistakes. You also conceded that your motion to dismiss does not respond to the new allegations set forth in the First Amendment complaint, and that you are not and will not be advancing any arguments directed to those allegations. All that did was remove 3 of the counts of the pleading. Okay, so all it does is moot those sections of the MTD. He doesn't have to advance new arguments. All you did was remove complaints. You have now emailed us an untimely revised motion to dismiss and have filed a notice with the court referencing your June 18th motion, but not what you emailed to us today. In any event, as we consider whether to request default, you don't have a right to default. It would be helpful for you to confirm that Ms. Reed will not be making any arguments directed to any allegations that were added in the First amended complaint, and that she will move for an extension of time to permit late service of the MTD emailed to us today and request a corresponding extension for our response until July 13th. Bro, you don't need to move for anything. You can agree. You both get to agree. The judge is only supposed to enforce the deadlines when you're petty children. Oh my goodness. Chris, it seems... Oh, here it comes from Mr. Rosenberg. Chris, it seems that you may have misheard part of our conversation. I did not concede anything about what our current motion does or does not refer to or argue. Kiernan, Attorney Murphy, said that your team believes our motion does not adequately address allegations made in the amended version of your pleading. And I said that is not a basis for default. It is an argument for you to advance in your opposition if you so choose. Hey, that's what I said. Nor did I commit to not advancing any arguments. I told you and Attorney Murphy that we would serve a corrected version of our prior motion, which would not contain any substantive changes and would only change the caption and paragraph count number in our citations, which we've now done in clean and red line form. So Judge wants to see that probably. Only Rule 9E, notice of motion to dismiss, refers to the date when we served our motion to dismiss June 18th, and is accurate. You have not requested any extension of time. If you do so, we are happy to consider it. Finally, just to be perfectly clear about your default threat, Rule 55 only applies when a party fails to plead or otherwise defend. That is patently not the case here. As I said on the phone, I want to avoid this kind of unproductive back and forth between counsel, particularly in filings with the court. They only serve to delay litigation and distract from the substantive issues in the case. But if your team files a pleading or affidavit saying we either failed to plead or failed to defend after we 1. Appeared in open court, 2. Worked with the court to set a briefing schedule, 3. Served a motion to dismiss, and then 4. Conferred with you about inadvertent errors in the motion, such a filing would necessarily be false. He's saying he'll file an ethics complaint if this dude files a Rule 55 notice of default on the record that he just created. And then Murphy says back, and this is the next day, June 24th at 12:33 p.m. Aaron, based on the language in your 9E notice, which references only the motion served on June 18th, can you please clarify which version of the motion to dismiss that Ms. Reed intends to ultimately serve in the 9A package? The one that was updated. Oh my God, are you obtuse or just being a jerk? If Ms. Reed intends to file only the corrected motion that was served yesterday, that's what they said. Plaintiffs intend to file an emergency motion seeking to strike your Rule 9E notice and to clarify which motions plaintiffs are required to respond to. Okay, how badly are you furious that discovery is going to get stayed in this case? We are available this afternoon to confer on that emergency motion, which they never ended up filing. Oh my God, it is the plaintiff's attorneys that's causing all of this. Why is Judge Gilday... Oh, Judge Gilday probably has finally realized it was not Karen's attorneys, it's these guys. And then Aaron Rosenberg replies, this is June 24th at 12:48. Attorney Murphy, your email omits from the chain my conversation with Chris, Attorney Maddie, last night on this topic. I've pasted that conversation below your messages from today. We plan to file the corrected version of the motion with the 9A package, which we provided yesterday immediately after you notified us of the non-substantive issues we fixed. Our 9E motion correctly states that we served a motion to dismiss on June 18th. As I said below, if you have a concern about timing and want to request a few extra days to oppose as a result of the corrections, we're happy to consider any such request. Okay, then Murphy says on June 24th at 5:40, Aaron, understood. What is your availability for a 9C conference tomorrow? I can be available before 10 or after 12, before 10 a.m. or afternoon. Kiernan then replies to himself on Thursday, June 25th at 1:43. Aaron, following up here, we noticed that Ms. Reed's 9E notice was e-filed prior to our receipt of the corrected motion. Do you intend to file a corrected 9E to reflect that a second motion was served on June 23rd? If not, can you please provide your availability for a 9C? Then Murphy follows up to himself again on June 26th at 12:31, and this is the end of what Murphy provides to the court. Murphy then says, Aaron, you have ignored my email for 2 days. Regardless, so that the record is clear, we have not agreed to accept nor do we consent to any amendment to your June 18th motion. Rule 9A does not afford Ms. Reed the opportunity to unilaterally supplement or amend a motion. Oh my God, because of a caption? Indeed, your notice to the court indicates the motion was served on June 18th. Accordingly, we expect to see in the 9A package filed with the court the motion that was served on us on June 18th. No, you moron. You told them that it was incorrectly captioned. What are you doing? Judge is going to hate you. Judge is going to hate this lawyer, Kiernan Murphy. He is going to hate him. What are you doing, counsel? Are you out of your mind? Counsel, you pointed out the flaw. It's not a substantive flaw. It's literally a caption because the trial court sua sponte moved the matter from Barnstable to Plymouth on the same record. You, counsel, you are the one who pointed it out. And now you want her to file the incorrect one to bootstrap in your ability to file a false 55D or whatever it is, notice of default? How desperate are you? How scared are you as a lawyer? What is going on right here? You're a jerk. What a dick. No wonder Judge Gildea is pissed. He's going to rail on this guy if he is indeed calling it down the middle. How dare you? And it gets worse. Oh, it gets worse. And then, let me just continue reading. Accordingly, we expect to see in the 9A package the motion that was served on June 18th. Should Ms. Reed fail to do so, or should you seek to amend your 9A motion after service, will seek appropriate relief. Plaintiffs reserve all rights with respect to this issue. And that's all he provides. Well, what did Judge Gildea just prove? Judge Gildea just ordered Attorney Seligson to give over the email that Attorney Rosenberg sent to Attorney Murphy at like 60 seconds later, and Attorney Murphy did not include it in his pleading, making it look like Attorney Rosenberg just ignored him. That's a fraud on the court. Oh, he caught him. He caught him. Oh, this case is off the rails. It's because of the plaintiff's attorneys too, and now I've seen the record. I've seen it with my own eyes, and a maid. Why did that same attorney how am I even going to write this up? For the H.A.M parties also send a number, oh, God bless you, who is that? Jackson, thank you so much. Send a number, also mislead Judge Gildea into thinking Karen's lawyers never responded to an email about a ridiculous argument raised by the H.A.M lawyers. Karen's lawyers did in fact respond by email, and the H.A.M lawyers simply left that email out of their filing. The core dispute raised by H.A.M shows pure desperation, and also explains why Judge Gildea is now furious at the H.A.M lawyer, as H.A.M is seeking to punish Karen under Rule 55D with a default, because her lawyers captioned the original motion to dismiss with the header from Barnstable Superior Court, where the case was filed, rather than Plymouth Superior Court, where the case was moved. Literally, talk about, that's not lawyering, that's being a child. Literally a child. That might work against like a defendant like Alex Jones, but it's not going to work against the heavyweights of the legal community. Are you out of your mind? Karen's lawyers rightfully pointed out that was a ridiculous position for the H.A.M lawyers to take, and frankly, I think Judge Gildea agrees. Requirement by Attorney Murphy before. All right. I mean, my word, I've never seen anything like it. This thing is completely off the rails. I just read those emails and I don't believe it. I don't believe it myself. Where are those emails? I gotta download these. Hold on one second. GSE, H.A.M lawyer misleads Judge Gildea by failing to include email attachment. I just can't believe what I'm saying. I mean, every time you think this... First of all, I forgot to get my food, and I'm very hungry, so I'd like to go get it. But I got to finish writing up this story. I mean, that was a big one. And people, I don't think, would have understood what had just happened unless I did that. Because you really got to know what you're doing. That's a big deal. That's a really big deal. And Judge Gilday is changing his tune, and he's rightfully going to be very mad at the H.A.M lawyers. They lied to him. They manipulated him. He's got to be pissed. I'm offended on his behalf, and I haven't exactly agreed with him on everything. Some of his rulings have been fine. I haven't liked how he's approached this case. And even I'm upset on his behalf. I mean, and he's mad. You could tell he's pissed. He literally wrote in, hold on one second, read the filing from the H.A.M lawyers that left out that crucial email in attachment B here. All right. I got to get this uploaded. So what you have to do is you got to like download the file from Mass Courts, and you got to upload it. Now once it's on Google Drive, you got to click the share link. Then once you click the share link, you got to change the share settings so it can be viewed by anyone with the link, not edited, just viewed. It's this whole process. That's what Kyle and Dee Dee are doing. I think Dee Dee likes Mega. I personally prefer Google Drive. I mean, I just pay them for the storage, so it's worth it. It's the best that I found, other than Court Listener. New. Judge Gildea is furious, and it is finally directed at someone other than Karen Reed or Aiden Turtle Boy Carney. Let's just say the H.A.M lawyers got caught with their hands in the proverbial cookie jar, and the punishment could be severe. Oh, they use threats? Dude, what kind of lawyering is that? I don't respect that. Dude, you are up against Alan Jackson. You better know what you're doing. Seriously. I kind of want to screenshot some of these emails for the post too. I mean, but seriously, like, either be good or be good at it. I don't mean to be so vulgar about it, but like, what are you doing? It's Alan Jackson. Like, yes, Seligsson's writing it and Rosenberg's writing it, but you're up against, like, the best lawyers in America. And you're acting like this, dude, they're gonna rail you. And quite frankly, they did. They embarrassed Maddie and Attorney Murphy in that email exchange. Dude, it's like watching a fourth grader talk to a graduate student. Karen's lawyers are just like, are you dumb? Like, they're being nice about it, but like, even Judge Gilday is gonna be like, are you dumb? Are you legitimately dumb? Like, how can you get it so wrong? And how can you be such a jerk about it? You know what I'm saying? It's just gratuitous. Like, you know, there was a saying I heard growing up. Drunk, fat, and stupid is no way to go through life. Well, petulant, wrong, and sanctimonious is no way to go through a legal career. Just saying. I mean, I'm just saying. But what do I know? We're going to get back to that other motion. This news just dropped, though. And no one would have got it. I feel like it's so... Like, Judge Gilday's trying not to embarrass the lawyers. There is some dignity. You wouldn't believe it. But there is some dignity in the legal profession that Judge Gilday is trying to preserve. But I think he's up against a rock and a hard place. Now I understand why he's so mad. And the only time judges ever get really, really pissed off is when lawyers act like children. Because the whole point of the profession is judges aren't supposed to have to referee your childish disputes. All right, we're going to get back to our motion here. I'm going to go get my food, which I've been waiting for, but news broke. Priorities, you know what I'm saying? This is, Towel Girlfriend is like, Towel, Grant, you got to remember to eat. Well, yeah, now you understand why I don't do a good job remembering to eat, because things happen, you know what I'm saying? All right, let's get back to where we were. We are on page, I think this is the top of page 13. So Seligson did docket a response. It's just not up yet. And it's what Seligson's docketing today is proof that Rosenberg emailed the H.A.M lawyers back on whatever it was, June 26th, which the H.A.M lawyers did not include in their pleading, and that'll get you in trouble. All right, let's go to page 13. Hold on one second.
Date filed the 7th of July 2026, 4:48.
Thank you, British Reporter Towel. All right, we got to go to page, what are we at, the top of page 13? Yeah. All right, where are we here? That's 16. Where is the top? That's 15. 14. All right, so it should start with the name Kearney. That's 13. That says judicial body. So is that? Yeah, so it's we're actually going to go one page higher, and it's going to start with the word Kearney. And I'm going to go get my cheeseburger. I'll be right back. You take a listen to this.
Kearney, so that Mr. Kearney could selectively publish. Dot. For the purpose of casting suspicion on plaintiffs and away from Reed, see also id. Paragraph mark 67, alleging Ms. Reed. Us, ed. Mr. Kearney as a tool to seed the public discourse with defamatory material. B. The emotional distress counts 4 and 7. Counts 4 and 7 allege intentional and negligent infliction of emotional distress, based on Ms. Reed's alleged campaign of false and outrageous statements about plaintiff. Complaint paragraph mark 173, see also id. Paragraph mark 196, NIED count based on Reed's campaign of outrageous, cruel, and malicious lies. The emotional distress claims appear to be based on the same statements and conduct underlying the direct defamation count and the aiding and abetting counts. Therefore, for the reasons outlined above, these counts are also premised on Ms. Reed's petitioning activity. See Shea v. Walters, 720 F3D 76, 83, 1st CIR. 2012, Plaintiff's Claim 4. Negligent infliction of emotional distress dismissed because it grows out of the same nucleus of operative facts that spawn her defamation claim. Count 4 confirms that it alleges Ms. Reed orchestrated a coordinated campaign to falsely accuse the plaintiffs of murder and conspiracy to frame her, and funneled false statements to Mr. Kearney for maximum public dissemination. See complaint paragraph mark 175.5 in other words. The alleged purpose of Ms. Reed's statements and communications with Mr. Kearney was to widely disseminate her defense that plaintiffs were responsible for O'Keefe's death. Given this purpose and the widespread public dissemination, the statements and communications were petitioning activities. They were made in connection with an issue under review by a. Count 4, the IIED claim, also alleges that Ms. Reed hired a private investigator previously associated with Harvey Weinstein to confront plaintiffs. As explained in for Part 2, see this allegation does not support an IIED claim because there is nothing extreme and outrageous about hiring a private investigator to interview someone. There is no allegation that any of the plaintiffs were aware the private investigator was previously associated with Harvey Weinstein, and there are no allegations the investigator did anything beyond try to speak with Higgins. 5. 13. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Judicial body, and reasonably likely to enlist public participation in an effort to effect such consideration. Bristol Asphalt, 493 Mass. At 550, explaining the GL circa 231, section 59H. Immunize, S, in, broad category of conduct from suit unless devoid of merit, emphasis. Added. C. The civil conspiracy count, count 10. Plaintiff's final claim against Ms. Reed, count 10 alleging civil conspiracy, is also solely based on petitioning activity. The complaint alleges that the conspiracy between Ms. Reed and Mr. Kearney was an agreement. To defame the plaintiffs and to inflict severe emotional distress on them. Complaint paragraph mark 213. Again, the claim is based on the same allegedly defamatory statements and communications. They were made to widely publicize Ms. Reed's defense while proceedings against her were pending in an effort for an acquittal and/or to pressure the Commonwealth to dismiss the case and refrain from a retrial in the case of another hung jury. See Reed Aff. Paragraph Mark 10. Like the other claims, therefore, Count 13 is based on petitioning activity. B. Second stage, plaintiffs cannot show Ms. Reed's petitioning activities were devoid of any reasonable factual support. Because all of plaintiffs' claims against Ms. Reed are based on petitioning activity, 2. Avoid dismissal under the anti-SLAPP statute, the burden shifts the plaintiffs to show by a preponderance of the evidence that Ms. Reed's petitioning activities were devoid of any reasonable factual support or any arguable basis in law, and caused actual injury to them. C. Bristol Asphalt, 493 Mass. At 557. See also Doe v. Thorell, 106 Mass. App. Court 532, 535 to 536. 2026. As the SJC has stated, this is a difficult task, and even the submission of an affidavit showing a material dispute of fact does not suffice to show the petitioning activity was devoid of. 14. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Any reasonable factual support. Bristol Asphalt, Supra. At 557 to 58. 6 in this case, plaintiffs cannot clear this, high bar, Blanchard, 477 Mass. At 156 N.20, because there is ample evidence supporting Ms. Reed's statements that plaintiffs caused Ms. O'Keefe's death and then tried to frame her. Of course, the simple and dispositive answer to whether Ms. Reed's defense, that she did not kill Mr. O'Keefe and that multiple parties attempted to frame her, is devoid of any reasonable factual support or arguable basis in law, was answered already on June 18, 2025, when a jury acquitted Ms. Reed of all charges relating to the death of Mr. O'Keefe. See Fabra v. Walton, 436 Mass. 517, 524, 2002, holding that judgment in favor of party to litigation is conclusive evidence that the petitioning activity was not devoid of any reasonable factual support or arguable basis in law. Baker v. Parsons, 434 Mass. 543, 555 N. 20, 2001, noting that I.T. is not enough for plaintiff to show that defendant's alleged petitioning activity was based on an error of law. He must show that no reasonable person could conclude that there was a basis in law for his position. There is no need for this court to reinvent the wheel here. Putting that analysis aside for the moment, however, the evidence supporting Ms. Reed's position remains overwhelming. Below is a sampling. Ms. Reed did not strike Mr. O'Keefe with her vehicle. See Reed Aff. Paragraph Mark 5. The Massachusetts Chief Medical Examiner testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike but rather a physical altercation. See testimony of Dr. Irene Scordi-Bello, Ex. 1 to the Seligson Aff. Mr. O'Keefe did not show signs of a physical altercation before Ms. Reed dropped him off, and he and Ms. Reed did not have such an altercation before she dropped him off at the Albert's house. See Reed Aff. Paragraph Mark 6. The SJC's jurisprudence has tended to equate the standard under the anti-SLAPP statute with the concept of frivolousness. Bristol Asphalt, 493 Mass. At 559 to 60, quoting Demulus Super MKTs, Inc. vs. Ryan, 70 Mass. App. Court 259, 267, 2007. A claim is frivolous if there is an absence of legal or factual basis for the claim, and if the claim is without even a colorable basis in law. Id. Internal quotes omitted. Even where the petitioning does not end in the petitioner's favor, that does not, in and of itself, mean that it did not have some basis in law or foundation in fact. Donovan vs. Gardner, 50 Mass. App. Court 595, 601. 2000. 6. 15. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Mr. O'Keefe also suffered a contrecoup wound on the back of his head, which is consistent with falling on the ridged surfaces present in the Albert's home garage. See testimony of Dr. Irene Scordi-Bello, Ex. 1 to Seligson Aff. Mr. O'Keefe also suffered dog bite wounds and the Albert's German Shepherd had a history of aggression. See testimony of Dr. Irene Scordi Bello, X. 1-2. Seligson Aff. Mr. O'Keefe's phone was at some point inside the Albert's home. See testimony of Ian Whiffen, X. 3 to Seligson Aff. Ms. McCabe had used her phone to search at 2:27 a.m. on January 28 how long it takes for a person to die in the cold. See testimony of Richard Green, X. 4-2. Seligson Aff. In the early morning hours of January 29, 2022, Mr. O'Keefe's body was not present in the spot it was later found, as Brian Logren testified. See testimony of Brian, Lucky, Logren, X. 5 to Seligson Aff. Instead, a Ford Edge was parked in the spot, see id, though it was not present when Ms. Reed dropped off Mr. O'Keefe, see Reed Aff. Paragraph Mark 6. Brian Albert owned a Ford Edge at the time. See Brian Albert trial testimony, X. 6 to Seligson Aff. Dr. Elizabeth Lapasata, the former chief medical examiner for Rhode Island and a professor at Brown University, opined that Mr. O'Keefe died from a massive skull fracture that was inconsistent with a vehicle strike. See Exhibits 30 to 32. Appended to the affidavit of Jeffrey J. Pyle submitted in support of defendant Aidan Kearney's special motion to dismiss pursuant to the anti-SLAPP law.
We haven't been able to read
Dr.
that yet.
Lapasata further testified that due to the abrasions on the back of Mr. O'Keefe's head, the injury was most likely caused by falling backward onto a ridged surface, and she observed no evidence of any ridged surface where his body was found. Id. She also testified that she found no evidence that Mr. O'Keefe suffered from hypothermia. Id. She testified further that the wounds on his right arm were consistent with an animal bite or claw marks. Id. In addition, there is ample evidence that plaintiffs have made material misrepresentations in previous sworn testimony, rendering suspect any sworn statements offered in this case. Those misrepresentations include O'Brien Higgins. Mr. Higgins originally told police he went to the Canton Police Department on the morning of January 29th to do administrative work in the middle of a snowstorm. See testimony of Brian Higgins, X. 16. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. 13 to Seligson Aff. Mr. Higgins then told the grand jury and said he went to the Canton Police Department to move cars around. See id. Yet later at trial, video evidence showed Higgins moving a large parcel from one vehicle to another, disappearing into his office and then spending a period of time in another unseen area of CPD, and then finally exiting CPD. See Canton Police Department Incident Report, X. 10 to Seligson Aff. Mr. Higgins testified that he didn't speak to anyone after leaving the Albert's house until he was notified of Mr. O'Keefe's death the morning of January 29th. See id. X. 13 to Seligson Aff. However, evidence at trial showed that he and Brian Albert communicated by phone at 2:22 a.m. the morning before Mr. O'Keefe's body was found.
Breaking.
See Higgins Albert call logs, X.
An affidavit
Seligson
of Colin
Aff.
Albert. Hold on.
Nicole and Brian Albert.
An
On
affidavit
January
of
29th, they
British Reporter Towel. An affidavit of Colin Albert has just gone up on the docket. I repeat, it is not viewable. It's part of the motion. It's part of the opposition to the motion to dismiss. But we have an affidavit from Colin Albert. We have a declaration from Brian Higgins and a declaration from Jennifer McCabe. But whatever the affidavit from Colin Albert is, that's part of this Rule 9A package. That's not scanned in yet. But it did just go up. Alright, I'll keep you updated. Alright, let's go back to listening to our motion. Sorry for the delay. Well, it's not really a delay. I monitor dockets, because I'm a town. Alright, where are we? Go
On
ahead.
January 29th, they told Sergeant Lang that their daughter, Caitlin Albert, was only briefly at the Albert's house and left around 12:15 a.m. See Canton Police Department, at page 8, paragraph mark 6, X. 10 to Seligson Aff. However, Caitlin was later interviewed by MSP and said she was the last to leave 34 Fairview. See Massachusetts State Police. Interview of Caitlin Albert, X. 9 to Seligson Aff. Trial testimony by all the House defendants confirmed Caitlin was the last to leave the Albert's house at around 2 a.m. See transcript of trial testimony of Jennifer McCabe, X. (11) to Seligson F. Nicole Albert told police she was asleep until Ms. McCabe came into her bedroom just before 7 a.m. on January 29th. See transcript of trial testimony of Nicole Albert, X. 14 to Seligson F. However, call logs show a 38-second answered call from Jen to Nicole at 5 hours 7 minutes and 21 seconds a.m. See Jennifer McCabe phone records at page 11, X. 12. To Seligson F. Brian Albert testified that he didn't make any calls during the night of January 29th, but call logs showed activity between him and Brian Higgins at 2:22 a.m. See Brian Albert trial testimony, X. 13-2. Seligson F. O. Jennifer McCabe. Ms. McCabe falsely identified herself as Nicole, interviewing FBI agents and falsely told them that she had not made any phone calls in the brief period after the agents first showed up and then returned for questioning. See Jennifer McCabe trial transcript, X. 11-2. Seligson F. After being threatened with the penalties of lying to 17. Date filed the 7th of July 2026 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Agents from another organization, Ms. McCabe admitted to calling her husband, Brian Albert, Peg O'Keefe, and Adam Lally. CX. 11. To Seligson F. Ms. McCabe admitted during her trial testimony that she went to Sergeant Lank's house on January 30th until the defense presented her phone's location data. CX. 11 to Seligson F. She also testified that she drove straight to Sergeant Lank's house from the O'Keefe's house, but her path of travel showed she went directly to Sergeant Lank from her own house after stopping at the Albert's house. CX. 11 to Seligson F. She also denied ever stopping at the Albert's house, but the phone data at trial revealed a 5-minute stop on the way to Sergeant Lank's residence. CX. 11 to Seligson F. Ms. McCabe falsely told first responders that Ms. Reed said, "Could I have hit him?" CX. 11 to Seligson F. She later testified at trial. Ms. Reed said, "I hit him, I hit him, I hit him." CX. 11 to Seligson F. Besides the physical evidence and the evidence that plaintiffs have made numerous material misstatements in previous testimony, plaintiffs have also destroyed multiple pieces of evidence, with the knowledge that the evidence would be relevant to any prosecution and later civil litigation. Mr. Higgins and Brian Albert destroyed their phones after a court order to preserve them. See testimony of Brian Higgins, X. 13 to Seligson F. Even though she didn't destroy her phone, Ms. McCabe deleted many of her texts as well as the 2:27 a.m. Google search. See testimony of Richard Green, X. 4 to Seligson F. At the very least, the court should draw an adverse inference that the deleted information would not have supported plaintiff's statements that they had nothing to do with O'Keefe's death. See Fletcher versus Dorchester Mutt. Inns. Company, 437 Mass. 544, 550, 2002, where evidence has been destroyed or altered by persons who are parties to the litigation. Dot. And another party's ability to prosecute or defend the claim has been prejudiced as a result, we have held that a judge may exclude evidence. To remedy that unfairness, Gaff vs. H.A.M, Inc., 440 Mass. 482, 488, 2003, summarizing. Available sanctions for spoliation. 18. Date filed the 7th of July 2026 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Given all of this evidence, plaintiffs cannot carry their burden at the second stage of the anti-SLAPP analysis to establish that Ms. Reed's statements were devoid of any reasonable factual support. Dismissal of plaintiff's claims against Ms. Reed is therefore appropriate under the anti-SLAPP statute.
Okay, so that's part one. Okay, Karen's actually doing a combined motion. You're all doing a really good job following along with this. I'm going to give Kofi a bunch of bonus points. I love when the bot says ... I agree. It's actually not really a bot. It's more of a accessibility tool for people with visual impairment. It helps you process long documents. It helps me as someone with a disability, like especially with my throat. So I like it a lot. But anyway, he does have his ways of saying ... All right, that was part 1. That was the anti-slap. We can't finish though. Folks, you must understand. I thought we were just going to be reading some motion practice. When we get to the reply, oh, listen, these H.A.M defendants must be screwed, because just the emails involving the H.A.M defendants, remember, Judge Gilday is really mad that he got misled, and he got misled about the response that the H.A.M defendants wrote to this motion. And we can't even get there until we get through this second part of the motion. So now we're going from the anti-slap motion to dismiss, which is Karen saying my statements were protected because they were petitioning activity. Very good arguments there. Almost all the in fact, all of them, all of the statements that are the basis for this civil lawsuit, Karen's lawyers argued were petitioning activity, pure petitioning activity, directly, indirectly, or otherwise, under this statute. And it's a pretty good argument. Pretty good. Now we're going to read what's called a 12b6. It's a combined motion. So Karen's now going to say, and by the way, Your Honor, not only is this protected by the anti-SLAPP statute, but if you don't find it is, dismiss it for failure to state a claim under 12b6. And now we get to read that part. Oh, I know you've always wanted to learn about 12b6 motions, but that's why you got to start at the beginning and just push it through. Chris, hello, Chris, how you doing? TNN for the win. Hi, Grant and Towels. Chris, it's so good to see you. You're wonderful, my dear friend. God bless you. I hope everything has been well.
Plaintiff's claims do not state a claim for...
I just want to say hello to Chris. Hashtag towel shoes. They're hanging out. I still don't have my glass case, but I got to protect it. God bless you, and let's continue.
Plaintiff's claims do not state a claim for relief and should be dismissed under Mass. RCIV. P12B6. Even if the court denies the special motion to dismiss, plaintiff's claim should still be dismissed pursuant to Mass. RCIV. P12B6 for numerous reasons. A. Count 1. Defamation. Count 1 of the complaint alleges defamation, which requires proof that the defendant was 1. At fault for 2. The publication of a 3. Statement regarding the plaintiff, 4. Capable of damaging the plaintiff's reputation in the community, which 5. Either caused economic loss or is actionable without proof of economic loss. Killnap enters. Inc. vs. Mass. State Auto. Dealers Ass and A9 Mass.
Pause.
App. Court 212.
I want to talk about something.
2016.
Pause. Pause. Amateo.
1.
Pause. Thank
The
you.
complaint does not comply with Mass.
Didn't I say pause? Thank you. All right. Remember how we talked about what a tort is? You see those 5 things right there? The H.A.M plaintiffs have to prove that Karen was at fault, part 1, for the publication of 3. A statement regarding the plaintiffs, 4. That was capable of damaging the plaintiff's reputation in the community, and which either caused economic loss or is actionable without proof of economic loss. And we'll find out more about that in a second. That's the standard for the tort. It's different than a criminal standard. Okay, that's the standard. Now, Karen's lawyers are going to argue the technicalities of why the complaint should be dismissed.
The complaint does not comply with Mass. RCIV. P8. Because it does not specify the allegedly defamatory statements. Count 1 should be dismissed because plaintiffs do not identify which statements made by Ms. Reed allegedly constitute defamation. Instead, they state the complaint does not include each and every example of Reed's and Kearney's defamatory statements and conduct. Complaint at 5N.1. Count 1 itself does not identify any statements apart from the generic allegation that Ms. Reed made false statements asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in that murder. Id. Paragraph Mark 147. This vague pleading runs afoul of Mass. RCIV. P8A's short and plain statement requirement because it does not provide Ms. Reed with notice of 19. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Basis of plaintiff's claim against her. C. Calorio vs. Marks, 72 Mass. App. Court 382, 386. 2008, a complaint must, however, contain a short and plain statement of the claim, which affords fair notice to the defendant of the basis and nature of the action against him. Citations. Omitted. The complaint's vagueness makes it impossible to formulate a response to the allegations. For instance, the complaint alleges that Ms. Reed's alleged defamation campaign began on April 18, 2023, see, e.g., complaint paragraph mark 33. Yet, the complaint also alleges that Ms. Reed knowingly and falsely told police before her second arraignment 7 that Brian and Colin Albert beat up Mr. O'Keefe and that she was not responsible for his death. See id. Paragraph mark 19. The complaint also refers to statements made in a discovery motion filed by Ms. Reed's attorney, which was forwarded to Mr. Kearney on April 12, 2023. See id. Paragraph mark 28 to 31. If these statements are the allegedly defamatory statements underlying count 1, they are subject to dismissal because they were made more than 3 years prior to the complaint's filing on April 16, 2023. C. GL circa 260, sections 2A and 4, Harrington vs. Costello, 467 Mass.
That's a typo. Typo.
720, 725,
Pause.
2014, defamation claim.
Pause, that's a typo.
Accrues when defamatory statement published to third party. The statements made in the
Pause.
discovery motion are also
This is a typo. This should say 2026. That's fascinating. That's fascinating. And then Karen's lawyers are also saying, wait a minute, the H.A.M plaintiffs here are making no sense. They're saying this campaign began in April of 2023, and then they're saying part of what Karen did that was actionable was what she said to the police like months, if not more than a year prior. All right? And then that's a typo. They're saying the claims about some of the statements are time barred because they occurred 3 years prior to the date the complaint was filed. And it's just a typo. It was 2026. Hello, Triply Bob. You are a
motion are also
towel.
absolutely privileged under the litigation privilege. See Corellas vs. Viveros, 410 Mass. 314, 319, 1991, statements made in the course of a judicial proceeding.
President Trump finally authorized the license for Ukraine to produce the very important Patriot interceptors. They're like the best version of it. They get to make them now. It was a big deal.
Which pertain to that proceeding are, of course, absolutely privileged and cannot support a claim of defamation, even if uttered with malice or in bad faith. The other statements by Ms. Reed identified in the complaint similarly do not constitute actionable defamation as explained infra. Part 2. A.2. 7. Ms. Reed made the statement.
Oh, wow, Triple Bob, I'm so glad I get to tell you this, that you're going to be thrilled. So, there was this waiver on President Trump's desk for a long time, and then yesterday in Turkey, after Mr. President Trump met with President Zelensky, he approved the waiver. Now, America can only produce 650 of the most important Patriot interceptors per year. They're a very special kind of Patriot interceptor. I think our quota now, and remember, we're going to buy them from Ukraine. I'm sure we are going to get a great deal. And then we're going to sell part of what Ukraine produces, and then Ukraine gets to use them. They are the only country in the world, other than the U.S., with the license to produce these Patriot interceptors. Now everybody wants these. Everybody. Because they're some of the only missiles that can intercept hypersonic ballistic missiles. Oh my god. Well, first of all, this missile costs like $4 million to fire. It's an interceptor missile. Second of all, it's a very big deal that we gave the license to Ukraine to do it, because they have the defense industrial base to produce them. We have the defense industrial base to produce them, but we limit the amount that can be produced. If we let Ukraine produce them, and it's not as big of a risk for us to be making them domestically, oh yeah, it's going to be a game changer in Ukraine. Oh yeah, not just that, Tripoli Bob, it turns out that what changed the course over the last month, did you notice Triple Bob, I'm sure. Just give me a moment here before we go back to this motion to talk to my dear friend Triple Bob. Now, Triple Bob, I was kind of analyzing the strike depth, like 1,500 kilometers, 2,000 kilometers, 2,500 kilometers, and I was like, you know what? There's just something weird about after that cathedral got struck, the 1,000-year-old UNESCO site. After Putin struck that cathedral, I heard that President Zelensky personally showed, like a month ago, a picture of it to President Trump. And President Trump lost it. He was pissed. Okay, well, I read a report yesterday that for the past month, none other than the American intelligence community has been helping to coordinate those long-range strikes on Russian oil infrastructure deep in Russian territory, including in Moscow. And then yesterday, the railroad that America strikes, maybe Israel, up in the north of Iran to the northeast of Tehran, that's that brand new overland railroad that Russia and China just built an extension of near Tajikistan to get Iranian oil overland to China and Russia without needing to use the waterways in the south of Iran. Well. Mishigama, these, as much as it's strange, these aren't like aggressive missiles. They're actually the best form of defense you can have. The more of these missiles exist, the less likely it is people will fire other missiles. If you have an $8 million hypersonic missile and you fire it because you adjudge that the other side doesn't want to fire their $4 million interceptors that they don't have a lot of, during the 60-day war in 2026, Israel fired 100 of its interceptors, its Patriots. They fired way more of the other ones. America fired 200 Patriots. Right? We don't have that many left. We had to readjust our Pacific stockpiles to be able to keep supplying those ships in the ocean near Israel with interceptors to be able to intercept those Iranian hypersonics, and we didn't get them all. And remember, an Iranian hypersonic makes you burn a Patriot interceptor to get the main warhead if it's a Khorram Sharhar, which is like a 1,500 kilogram hypersonic, and then to really punish you, even if you intercept that hypersonic, it drops the bomblets, right? And we know what those do. So, yeah. But anyway, it's a big deal that this it was on President Trump's desk forever, like a year. Now that it actually got approved, it's a game changer. I don't think Putin will last much longer in this war. He can't. He's losing his oil production capabilities at an astounding rate. The attrition rate on Russian domestic oil production, not to mention like the chemical rain that has been caused across like massive portions of Russia. Who knew the trick to beating Russia wasn't invading them by land, it was making it rain oil. Literally. Let's go back to the motion. Seriously though, very big developments right now over the past 48 hours on the Russian-Ukrainian front. I expect the war to be over by Christmas of this year. I think Putin wants a land corridor to the sea. What is it? The Baltic. I think he does. I don't think he's going to get it. But that's the last sort of sticking point. He's also running out of money, so.
Ms. Reed made the statement in June 2022. 20. Date filed the 7th of July 2026, 4:48 p.m.
Triplet Bob, you're absolutely right. The wild card is always that after a domestic election, there's a double down, which we could see with Mr. President Trump too. The only difference is Putin doesn't have to worry about the Duma. After 2008, he pretty much got them under control. What Putin has to worry about is the oligarchs. Like, if the West is going to overthrow Putin, like, without it being... If they're going to do a color revolution in Russia, it's not going to be through military force. It's going to be through the oligarchs. Putin tamed a lot of them, but a lot of them got to the West. So, anyway, I don't mess around with that stuff. It's not my call whether or not the best policy for the United States is to, like, utilize disaffected Russian oligarchs to overthrow Putin. That is one of those things where I would never intervene. I inadvertently almost got involved in that one time. It was complicated. It was really weird. It involved like a Cypriotic holding company and the guy who owned the Chelsea Football Club, Roman Abramovich, and this other guy named Andre Block, and then his son, and then this other guy named Boris Jordan. It was all very interesting. I learned a lot of stuff, and then I was like, you know what? I don't know if I want to do that stuff. You know, you all have a good time. and then I didn't report on it anymore because I don't really want to be involved in that. Now listen, you think people coming to my house was weird during the Epstein stream? When I started looking into like Cypriotic holding companies for disaffected Russian oligarchs, I don't even want to tell you what happened during that one. Let's just say it wasn't very pleasant. And then Mr. Government official, who's now in the private sector working as a lobbyist, I know who spoke to the Globe. They didn't tell me, I just figured it out. That man thought he would mock me and be like, oh, I don't see any reason why, Grant would be concerned and go to ground. Well, Mr. Government man, I can't call the local police and have them send cop cars by my house to monitor me. I gotta take things, my personal OPSEC into my own hands. So I went to ground. I'm glad you felt safe with the local police guarding you from the Russians, Mr. Government man. But I had to take, different security approaches. Anyway, you can read about that in Tory Bedford's excellent article for WGBH, which, if you just Google WGBH, Tory Bedford, Grant Smith Ellis, you can read all about my spring 1L semester of law school. I remember the day that I had to, go to ground for 2 weeks. I went in, to class, and I gave a hug to my dear friends, and I was like, I don't know if you're going to see me again. And they were like, what's going on? And I was like, I think it's better that you don't know. And then I told, my editor knew what was going on. And I was like, all right, I gotta go. And they were like, go where? And I was like, you don't want to know. And then I just left. It was quite interesting. Hello, Mr. and Mrs. Sweeney. Listen, Mr. and Mrs. Sweeney.
However, apart from the statement...
It's gonna take me another, 3 hours, maybe 2 hours, but you're gonna want to see this. The H.A.M lawyers, Higgins, Albert, McCabe, they are in hot water with Judge Gilday. Everything has turned. It's like the Argentina versus Egypt World Cup game. Judge Gilday definitely was given a 2-0 lead to the H.A.M lawyers. He was scolding Karen's lawyers all over the place. As you know, Mr. and Mrs. Sweeney were at the hearing last week when I was on my towel staycation when I saw my towel Nana. But anyway, I should have brought Towel Nana to the hearing. She might have got a little overwhelmed, though. But my point is, wait till you hear this. It's like Lionel Messi himself has embodied Damon Seligson and Aaron Rosenberg and Alan Jackson, and they somehow got things to 3-2 Argentina instead of being down 2-0. Now, how did it happen? I'm going to explain it to you. It was actually one of those unforced errors. I'm really mixing my metaphors here, but I like tennis too. It was one of those unforced errors where the H.A.M lawyers tried to throw the ball up and hit it 120 miles an hour into the opponent's box, and then they just missed the ball, and the ball fell down on the court and then bounced back up, and then Damon Seligson just kind of hit it. And then we're really off the metaphorical track here, but the point is, it gets really good because the unforced error component of it, which I totally messed up, was that the H.A.M lawyers, in their opposition to this very motion, committed basically, it might have been unintentional, a fraud on the court. They told Judge Gilday that Karen's lawyers just stopped responding to them by email. So Judge Gilday was like, Mr. Seligson, by this morning, show me an email where you responded, or someone on your team responded to this. Seligson files the email from Rosenberg to the H.A.M lawyers this morning. Within 30 minutes, Judge Gilday drops an order being like, all right, Mr. Kiernan Murphy from Chris Maddie's firm or whatever it is, you explain to me right now why you filed an opposition to Ms. Reed's motion to dismiss that tells this court, as in your appendix B, that there was no response from Karen's lawyers when I now have that response from Mr. Rosenberg to you. Now we wait. Yes, Triple Bob, we call him H.A.M. All right. Let's go. So it's going to take a little time. We're going to spend the afternoon with Tao. And then, we're going to get through this. And hopefully, bombs don't fall. If the IRGC could just, let me read some court motions. If we could just have no bombing. That goes for Mr. President Trump, too. Can we all just, do other things? I don't know. Work on economic policy, sell some oil to some people, make a building, do some construction. All right, I want to read this court motion. All right, let's continue.
However, apart from the statement listed in the complaint, Ms. Reed cannot fully respond to count 1 to the extent it relies on other statements that are not included in the complaint. For that reason, count 1 should be dismissed because it does not provide a short, plain statement of the defamation claim. 2. Nearly all of Ms. Reed's actual statements listed in the complaint are not actionable defamation as a matter of law. As explained above, Count 1 cannot be premised on the June 2022 statement by Ms. Reed and the April 12, 2023 statements made in the discovery motion filed in Norfolk Superior Court, because the claims would be untimely and barred by the absolute litigation privilege. Other statements by Ms. Reed listed in the complaint are also not actionable defamation. A. Paragraph 49 statement about Albert testimony to grand jury. Paragraph 49 alleges that Ms. Reed told Mr. Kearney through an intermediary that Brian Albert, and other non-plaintiff members of the Albert family, testified to an investigating grand jury that Colin Albert was at the Albert's house prior to O'Keefe's arrival. This statement, even if false, is not defamation. A defamatory statement is one that discredits the plaintiff in the minds of any considerable and respectable segment in the community. Barrows v. Wareham. Fire Dist. 82 Mass. App. Court 623, 628, 2012. A statement that Brian Albert correctly told a grand jury that Colin Albert was at the Albert's house does not discredit Brian Albert or injure his reputation. 21. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. B. Paragraph 50 statement about Feds involvement. Paragraph 50 alleges that Ms. Reed told Mr. Kearney through an intermediary that the Feds have been involved longer than anyone is likely guessing. This statement is not actionable because, even if false, it is not of and concerning the plaintiff. See Lee v. Zeng, 98. Mass. App. Court 743, 747, 2020. In other words, the statement does not refer to the plaintiffs and no person could reasonably understand the statement referred to plaintiffs. See id. In addition, the statement is not one of fact, but rather an opinion about the length of federal involvement. See id. Furthermore, to be actionable, the statement must be one of fact rather than opinion. C. Paragraph 51, January 29, 2022 voicemail excerpt. Paragraph 51 implies that Ms. Reed or her legal team provided an excerpt of a voicemail. Ms. Reed left Mr. O'Keefe the morning of January 29, 2022, which captured Ms. McCabe's call to 911. There is no allegation, however, that Ms. Reed made any statement of or concerning Ms. McCabe or the other plaintiffs, and no allegations that any statements in the voicemail were false or injurious to plaintiff's reputation. D. Paragraph 58 Unity Text 3 HPO. The next statement the complaint attributes to Ms. Reed or her lawyers is in paragraph 58, which alleges that Mr. Reed's attorney, Mr. Unity, texted Mr. Kearney that the Stoughton District Court had denied an ex parte harassment prevention order Ms. McCabe had sought against Mr. Kearney. This true statement cannot be defamation. See Riley v. App, 59 Mass. App. Court 764, 769, 2003, holding that plaintiff must show statements in question were capable of being proved false, and also does not tend to discredit Ms. McCabe or injure her reputation. 8. The statement relaying the denial of the harassment prevention order is also privileged under the Fair Report privilege. See Jones v. Tybee, 400 Mass. 786, 794, 1987, there is a well-established privilege to publish reports of judicial, legislative, or other official proceedings. 8. 22. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. E. Paragraph 75 Facebook group hosting and posts. Paragraph 75 alleges that Ms. Reed was co-administrator of a Facebook group that became a feeding ground for defamatory and harassing posts made regarding the plaintiffs. But the paragraph does not allege what statements were made, when, and by whom, nor does it allege that Ms. Reed was responsible for any of these third-party posts. If Ms. Reed did not make or publish the unidentified statements, she did not defame plaintiffs. See Phelan v. May. Department Stores Company, 443 Mass. 52, 56, 2004, noting that to prevail on a defamation claim a plaintiff must establish that the defendants published a false statement, emphasis added. 2. The extent plaintiffs are alleging Ms. Reed's administration of the Facebook group constitutes Defamation. She is immune under Section 230 of the Communications Decency Act, 47 U.S.C. Section 230, c. 1. Courts analyzing and applying the CDA have consistently held that distributing, sharing, and forwarding content created and/or developed by a third party is conduct immunized by the CDA. See Monge vs. Univ. of Par. Number 222942, 2023 U.S. Dist. Lexus 40724, at *8, ed. Par. March 10, 2023, collecting cases. As for Ms. Reed's own statements on the Facebook page, the complaint does not allege any were false, just that she shared confidential information regarding her criminal case that had not been previously known to the public. Complaint paragraph mark 75. The complaint also does not allege that any of Ms. Reed's Facebook posts concerned plaintiffs or injured their reputations. Without alleging these basic elements, any defamation claims premised on Ms. Reed's unidentified Facebook posts fail as a matter of law. F. Paragraph 115 Statement by Jackson to Nightline. Paragraph 115 alleges that Ms. Reed's attorney, Mr. Jackson, said on an episode of ABC's Impact X Nightline show that there are people in that house that are actually 23. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Responsible for his death, and who murdered him. And there are others in the house that are covering up that murder. It also alleges that Mr. Jackson said that Ms. McCabe knew Mr. O'Keefe was murdered in the house and that his body was placed outside. See id. Any defamation claim premised on these statements should be dismissed. The complaint does not allege Ms. Reed is vicariously liable for her attorney's statements. Even if it did, a principal's vicarious liability turns on whether the agent is liable. Green vs. Cosby, 138 F. Sup. 3D 114, 138, D. Mass. 2015. Thus, the complaint must plead that Mr. Jackson is liable for defamation, which requires an allegation he was at fault. See id. At 139. The complaint does not allege any fault on Mr. Jackson's part, whether negligence, recklessness, or knowledge of falsity. Thus, the complaint does not sufficiently allege Jackson's liability for defamation, and therefore, fails to allege Ms. Reed is vicariously liable for Mr. Jackson's statements. G. Paragraph 130 Statement on January 12, 2026 podcast. Paragraph 130 of the complaint alleges that Ms. Reed told the Rotten Mango podcast that Mr. O'Keefe entered the Alberts house and that someone in that house killed John O'Keefe. These statements do not support a defamation claim because they are not of and concerning any individual plaintiff. Instead, the statements are made generally about the group of people of the house, only some of whom were the plaintiffs. Defamation does not lie when a statement is made about a group, unless the size of the group or the context of the statement would make it reasonably understood the statement referred to the individual plaintiff. See Hipsaver, Inc. vs. Keel, 464 Mass. 517, 528, 2013. There can be actionable defamation when a defamatory statement applies to all members of a small group, or when the statement refers to multiple members of a small group. See Arkand vs. Evening Call. 24. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Pub. Company, 567 F2D 1163, 1164, 1st CIR. 1977, emphasis added, id. At 1165, that is, the defamation, encompassing a considerable proportion of the group, can be seen as a blanket slur, reaching all Here, however, the statement is only about a single unnamed individual in a group, which does not support an inference the statement referred to an individual member of the group. See id. But we have discovered no case where a group libel, justifying sued by all members, was held to arise from a slur against one unidentified member. B. The aiding and abetting and civil conspiracy counts 3, 6, 9, and 10 should be dismissed because the complaint does not allege how Ms. Reed substantially assisted Mr. Kearney other than making privileged
Yes. Thank you.
Counts 3, 6 and 9 allege that Ms. Reed aided and abetted Mr. Kearney's defamation, intentional infliction of emotional distress, and negligent infliction of emotional distress. To make out a claim against Ms. Reed for aiding and abetting Mr. Kearney's tortious conduct, plaintiffs must plead and prove that 1. That Mr. Kearney committed the relevant tort, 2. That Ms. Reed knew he was committing the tort, and 3. That Ms. Reed actively participated or substantially assisted in his commission of the tort. Go Best Assets, Limited. In or substantially assisted in his commission of the tort. Go Best Assets, Limited vs. Citizens Bank, 463 Mass. 50, 64, 2012. The civil conspiracy claim, count 10, has similar elements. There are two types of civil conspiracy. The first is a very limited course of action that arises when the defendants acting in unison had some peculiar power of coercion over plaintiff that they would not have had if they had been acting independently, et necas. So, Co. versus P&B Autobody, 43F3D 1546, 1563, 1st CIR. 1994. Plaintiffs do not allege this type of coercive conspiracy. Instead, they allege a concerted action conspiracy, in which liability is imposed on one individual for the tort of another. Kirker vs. Hill, 44 Mass. App. Court 184, 188, 1998. This type of conspiracy, like an aiding and abetting claim, requires plaintiffs to plead Ms. Reed knew that Mr. Kearney's 25. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Conduct, constitute, D, a breach of duty, and G, avenue, substantial assistance or encouragement. Id. At 189. 9. Both types of claims, the aiding and abetting claims and the civil conspiracy claim, must be dismissed for two reasons. First, Ms. Reed cannot be held liable for aiding and abetting, or conspiring to assist, Mr. Kearney's tortious activity if he did not commit a tort. As explained in Mr. Kearney's motion to dismiss, the tort counts against him do not state a claim. CPP 10-13 of defendant. Aidan Kearney's memorandum of law in support of his partial motion to dismiss pursuant to Mass. RCIV. P. 12, B. 6. Second, the complaint does not allege substantial assistance that would support aiding and abetting or conspiracy claims. The complaint alleges that Ms. Reed substantially assist her, ed, and encourage, ed, Mr. Kearney by when she, and intentionally provided defendant Mr. with non-confidential information about her criminal case, id. Paragraph mark 170, 193, 209, and by funneling information and false statements to Mr. Kearney, id. Paragraph mark 213. Neither of these actions constitutes substantial assistance for Mr. Kearney's alleged torts. With respect to sharing non-public information and as discussed above, the only alleged non-public, confidential information shared was 1. Reed's April 12, 2023 discovery motion, which had non-public documents attached to it, see id. Paragraph mark 28, 2. Statements about the Roberts grand jury testimony, id. Paragraph mark 49, 3, a statement that feds have been involved longer than anyone is likely guessing, id. Paragraph mark 50, 4, an audio file of Ms. McCabe's 911 call, id. Paragraph mark 51, and 5, the denial of Ms. McCabe's ex-party harassment prevention order, id. Paragraph mark 58. Both civil conspiracy claims and aiding and abetting claims in Massachusetts are based on Section 876(b) of the secondary statement. Ego Best Assets, Limited vs. Citizens Bank, 463 Mass. 1998, citing Section 876(b) for elements of civil conspiracy. 9. 26. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. All three aiding and abetting counts are based on the theory that sharing these pieces of non-public, confidential information helped Mr. Kearney spread the alleged false statements. That
Typo.
plaintiff killed Mr. O'Keefe and then sought to cover it up. The complaint does not allege, however, how sharing such information provided any assistance to Mr. Kearney to lie about. Plaintiffs. Other than the April 12, 2023 discovery motion, none of these alleged sources of confidential information stated or implied that plaintiffs were responsible for O'Keefe's death, and thus did not support or encourage Mr. Kearney's allegedly defamatory statement. Plaintiffs killed Mr. O'Keefe and covered it up. While the discovery motion did name Brian and Colin Albert as responsible for Mr. O'Keefe's death, and Ms. McCabe for covering it up, Ms. Reed is absolutely immune under the litigation privilege statements made in the litigation privilege for statements made in the motion. Yeager's Bonusing, Inc. vs. Ramsey, number 19 CVO 5418, Who, 2022 U.S. Dist. Lexus 211688, at asterisk 66, ND Cal. November 22, 2022, dismissing aiding and abetting claims premised on statements and conduct protected under litigation privilege. For the same reason, the allegation that Ms. Reed, ed. For the same reason, the allegation that Ms. Reed, ed. False. Statements to Mr. Kearney, complaint paragraph marked 213, does not support the civil conspiracy claim. The complaint's only allegation that Ms. Reed funneled false statements to Mr. Kearney was sharing the publicly filed discovery motion. See id. Paragraph mark 31. But Ms. Reed is immune from claims premised on her privileged statements made in the motion. C. Counts 5 and 9, IIED and NIED. Counts 5 and 9 assert claim for intentional and negligent infliction of emotional distress, respectively. Both claims are based on Ms. Reed's alleged campaign of outrageous and false statements. See complaint paragraph mark 173, 196. The claims are thus based on Ms. Reed's allegedly false statements. However, defamatory statements cannot, as a matter of law, satisfy. 27. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. The extreme and outrageous conduct requirement of the IIED claim. Iodori vs. Floor 64, Inc., 270 3D 343, 370 DMS. 2017, quotation and alteration omitted. Moreover, even if plaintiffs could maintain emotional distress claims based on defamatory statements, because the defamation claims based on those statements fail in this case, the emotional distress claim should also fail. See Soto LeBron vs. Fed. Express Court, 538 F3D. 45, 58, firsts in the guise of an IED claim, which would divorce it from well-developed law of defamation with its attendant privileges and defenses. In particular, the statements Ms. Reed made to the police in June 2022 and in the April 12, 2023 discovery motion, see complaint paragraph mark 19, 27, are protected by the litigation privilege. C. Corellas vs. Viveros, 410 Mass. 314, 324, 572 NE2D7, 13, 1991, because the statements which form the basis of Corellas's claim for intentional infliction of emotional distress were made in circumstances rendering them absolutely privileged, that claim must also fail. A privilege which protected an individual from liability for defamation would be of little value if the individual was subject to liability under a different theory of tort. Similarly, the statements referred to in paragraphs 49, 50, 51, and 58 about the Alberts' testimony to a grand jury, the Fed's involvement, a voicemail excerpt containing Ms. McCabe's 911 call, and the denial of Ms. McCabe's ex-parte harassment prevention order, do not injure the Alberts' reputation and thus cannot constitute extreme and outrageous conduct for purposes of an IED claim. See Bowman vs. Worcester Telegram and Gazette, 6 Mass. L. Representative 394, Worcester. Sup. Court 1996, the publishing of an opinion letter in a letters to the editor column which is neither false nor defamatory is not outrageous conduct of the newspaper. Similarly, because these statements are not injurious to plaintiff's reputation, no reasonable person would have. 28. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Suffered emotional distress, as required for an NIED claim. See Kelso vs. Kelso, 86 Mass. App. Court 226, 232 N.12, 2014. Likewise, the statements of Facebook posters and Attorney Jackson in paragraphs 75 and 115 cannot constitute IED, which requires that the actor intended to inflict emotional distress, or that he knew or should have known that emotional distress was the likely result of his conduct. Howell vs. Enter. Public Company, LLC, 455 Mass. 641, 672, 2010, emphasis added. They also cannot underlie an NIED claim, which requires that the claimed harm result from Ms. Reed's alleged negligent conduct, not the alleged defamatory statements of third parties. C. Restatement, 2nd, of Tort Section 432, 1, t. He actor's negligent conduct is not a substantial factor in bringing about harm to another if the harm would have been sustained even if the actor had not been negligent. Finally, the statement made to the Rotten Mango podcast that someone in that house killed John O'Keefe, complaint paragraph mark 130, does not support emotional distress claims because, as argued above, the statement does not identify a particular individual and thus are not defamatory as to any of them. 10. Count 4, the IED count, also seems to base the claim on the allegation that Ms. Reed hired a private investigator previously associated with Harvey Weinstein. Complaint paragraph mark 175. That conduct cannot form the basis for an IED claim for two reasons. First, hiring a private investigator to interview potential witnesses is protected by the absolute litigation privilege. See Goodman vs. Goodman, 226 NE 3D 704, 712. Ill. App. 2023, affirming dismissal of IED claim based on hiring private investigator. Second, the mere act of hiring a private investigator does not amount to extreme and outrageous conduct, especially where the complaint does not allege the investigator engaged in harassment or other improper behavior. Here, the complaint only alleges that the private investigator attempted to interview plaintiff Higgins once and was rebuffed. See complaint paragraph mark 68 to 69. There is no allegation of an invasion of privacy, no allegation of illegal conduct, and no allegation that Higgins suffered any negative effects from refusing to speak to the private investigator. Given that Higgins is a law enforcement officer, presumably used to hostile interviews, the mere attempt to talk to him is not conduct so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. See Restatement, 2nd, of Torts Section 46 CMT. D. 10. 29. Date filed the 7th of July 2026, 4:48 p.m. Superior Court, Plymouth. Docket number 2683 CV 00541. Conclusion. For the foregoing reasons, defendant Karen Reed respectfully requests that the court
Yes? I mean, we got to finish strong, British reporter.
allow her motion to dismiss, and she be awarded her reasonable attorney's fees and costs.
Okay, so we got through the first document. Now, normally, I would say, okay, good. We've done some good work. We'll analyze the merits, and then we'll analyze the opposition. Oh, no. There was a war over this motion. The H.A.M defendants are freaking out that Karen filed this motion. Now, what's interesting is I took a look at Aiden's motion to dismiss. It's 2 pages. It's fascinating. And the H.A.M response, hi Spacey, the H.A.M response is 34 pages. Now, before we get to Aiden's motion to dismiss, Aiden Carney's, we're going to take a look at whatever the H.A.M defendants said in response to Karen's motion here got them in a lot of trouble with the court. All right, so I'm going to bring this motion up for you. We're going to take a look at it. We're going to read it. All right, and we're going to come to understand what has happened to lead Judge Gilday to basically say that the H.A.M lawyers better have an explanation for why they misled him in the motion we're about to read, or I think Judge Gilday is going to be made. So, in terms of my analysis, you heard what's great about a motion like that is it doesn't assume you know anything. It tells you everything you need to know, all right? And if you listen to that all, you understood the anti-SLAPP arguments, okay, which stops discovery. Just the filing of this motion has stopped discovery in the, quote, defamation case or the Fair Trade Practices Act. Also, I saw Towel Girlfriend came in. Hello, Towel Girlfriend. I love you dearly. You're wonderful. That's the anti-SLAPP part. Then there's the 12b6 motion to dismiss for failure to state a claim upon which relief can be granted. Okay, now we're gonna look at the opposition, okay, that the H.A.M parties filed to the motion that we just read about Karen. Now this is the motion that got them in trouble with Judge Gilday. All right, specifically whatever arguments they make about attachment B to the affidavit. So when you see exhibit B or attachment B come up, our towel alerts go up, all right? Because somebody misled Judge Gilday about the exchange related to the filing of these pleadings. And then the H.A.M lawyers got so thrown off by Karen filing this motion to dismiss that they used a caption error on a document to suggest that Karen had failed to reply and thus violated Rule 55D, and thus the H.A.M lawyers were going to move for default due to a caption being from the Barnstable case instead of the Plymouth case. Ridiculous. The Barnstable case got moved to Plymouth. Hello, Norfolk Tyranny. Norfolk Tyranny. Hello, Just Shorty P. Hello, Danette. It's so good to see you. What is a 201 file? You might have to explain. I don't know if I said 201. Because a 201 file doesn't make sense to me in context. Maybe I said another term and you heard it as 201, but let's just figure out. You can ask a different question. I'll be happy to answer it as long just clarify what you mean. But now we're going to listen to this response that got them in a lot of trouble. I don't exactly know what they said. I don't know what they did. We're going to find out together, but it has to do with an email that the H.A.M lawyers said Karen's lawyers never responded to and presented to Judge Gilday that way, but which indeed Karen's lawyers did respond to. So now by 4:30 p.m. today, by July 9th, 2026, the H.A.M lawyers have to file an explanation for why this pleading misled Judge Gilday. So we got to read it. Oh, no, I don't think I'm muted. Olivia, hello, Olivia. You might just want to refresh. Thank you. Yeah, sometimes what it does is like the mic doesn't catch, or like there's a buffer. But either way, thank you for letting me know. I have this nifty little like green, yellow, and red bar, so I can kind of monitor the sound feedback in real time. It's kind of cool. Good to see you, by the way, Olivia. We're about to do my favorite thing in the entire world, which is read a pleading. I don't know really what it's going to say. That has upset Judge Gilday so much that Karen's team has pulled, well, and technically Aiden's going to be the beneficiary of this too. Karen and Aiden have pulled a Lionel Messi against Egypt. Somehow Judge Gilday is now mad at the H.A.M lawyers for misleading him, and it's about Exhibit B to the affidavit to this response to Karen's combined motion to dismiss under the anti-SLAPP statute and 12b6. Hashtag let's read it. I'm excited. I'm a towel. Hi, towel girlfriend. British reporter towel is like you are. Oh, British reporter towel is the guy who reads the stream, and towel girlfriend Nikki says British reporter towel is shrugging
July,
this
2026,
evening.
11:39 p.m.
He does good work. He's a good British reporter towel.
Superior Court, Plymouth.
Take it away, British reporter towel.
Civil action no. Plaintiffs, opposition to defendant Karen Reid's special motion. Plaintiffs, opposition to defendant Karen Reid's special motion. To dismiss pursuant to the Massachusetts Anti-SLAPP Statute, GL Circa 231, Section 59H, AND motion to dismiss pursuant to Mass RCIV. P. 12b6. Date filed the 7th of July 2026, 11:39 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Defendant Karen Reid's motion to dismiss, MOT, should be denied at the threshold because it is not directed to the operative complaint. Plaintiffs Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins, plaintiffs, filed the first amended complaint on June 5, 2026, adding detailed allegations concerning Reid's defamatory statements and conduct, including statements Reid personally made during recorded interviews with Terry Dan Moira and her production team. See paper number 22, AC, paragraph mark 1, 91 to 99, 120 to 123, 146 to 226. Reid's motion, nevertheless, is directed to the inoperative superseded pleading. It uses the former Barnstable caption, cites obsolete paragraphs and count numbers, and fails entirely to address the AC's new allegations. Contrary to Reid's anticipated position on this issue, that defect is not cosmetic. Reid's procedural and substantive misfire matters because the Moira allegations, wherein Reid accused plaintiffs of being first-degree murderers and participants in Officer John O'Keefe killing, are now central to plaintiff's direct defamation claim against her, and to plaintiff's theory that Reid knowingly participated in a coordinated campaign to destroy plaintiff's reputations. CMOT. At 2 to 3, 7 to 8, AC paragraph mark 91 to 99, 147 to 153, 175. A motion ignores the operative pleading cannot carry Reid's burden under either Mass RCIV P. 12b6 or the anti-SLAPP statute. On the merits, the AC alleges a straightforward and deeply damaging course of misconduct. Plaintiffs allege that Reid struck O'Keefe with the back of her Lexus SUV while intoxicated, made repeated admissions at the scene that she had hit him, and later abandoned those admissions in favor of a public relations strategy that falsely blamed plaintiffs for O'Keefe's death. AC paragraph mark 7, 1620. Plaintiffs further allege that Reid enlisted defendant Aidan Kearney, as a public mouthpiece, used intermediaries, counsel, and encrypted communications to feed him non-public information and defamatory narratives, praised his publications, coordinated with him around. 1. Date filed the 7th of July 2026, 11:39. Court proceedings and media events, and celebrated the resulting damage to plaintiffs' reputations. And to her own jury pool. Id. Paragraph mark 22 to 40, 47 to 58, 74 to 75. The result, as pleaded, was not constitutionally protected petitioning. It was a multi-year campaign of defamation, harassment, intimidation, and destruction aimed at witnesses in Reed's criminal case and sustained for profit, publicity, and litigation advantage. Id. Paragraph mark 1 to 3, 142 to 145, 147 to 153, 173 to 180, 211 to 216. For the following reasons, Reed's motion must be denied. I. Background. A. Procedural history. Plaintiffs commenced this action on April 16, 2026, in Barnstable County Superior Court, alleging that Reed and Kearney orchestrated a multi-year campaign to defame, harass, and torment plaintiffs by falsely asserting that they were responsible for O'Keefe's death and a cover-up. After the case was transferred to Plymouth Superior Court on May 27, 2026, plaintiffs filed and served the operative AC on June 5, 2026. The AC amended the initial complaint in numerous material ways. Yet, on June 18, 2026, Reed served a purported special motion to dismiss and Rule 12(b)(6) motion directed not to that operative pleading, but to the superseded complaint. The motion failed entirely to respond to a series of new allegations made against Reed, used the old case caption, and referenced non-operative count numbers and citations. See Declaration of Kieran T. Murphy in Support of Opposition, Murphy Decl. X. A. Only after plaintiffs inquired of Reed's counsel about Reed's failure to respond to the AC. Did Reed serve a revised motion on June 23, 2026, captioned in Plymouth County and key to the AC's paragraph and count numbers. That belated filing did not cure the Rule 9a defect, it merely preserved the same substantive attack while swapping in new citations. Reed's June 23 motion was untimely under Rule 9a, plaintiffs never consented to its service and plaintiffs put Reed's counsel on notice that their inclusion of the June 23 motion in the instant package would 2. Date filed the 7th of July 2026, 11:39 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Violate Rule 9a. C. Murphy Decl. X. B.1 Reed should not be permitted to deflect the court's attention from the massive procedural and substantive deficiencies that she answered the wrong pleading by reserving, after the deadline, a cosmetically corrected motion that merely changes citations and count references. B. Factual allegations. Plaintiffs were key witnesses in connection with the Commonwealth's investigation into O'Keefe's death and Reed's prosecution. AC paragraph mark 9 to 12. The AC alleges that, on January 29, 2022, Reed struck O'Keefe with the back of her Lexus SUV while driving drunk, left him incapacitated in freezing conditions on the front lawn of 34 Fairview Road in Canton, and repeatedly told first responders, "I hit him. I hit him. I hit him." Id. Paragraph mark 16.
Breaking, hold on.
Reed
British
was later
report,
indicted
British
for
reporter
second
towel, would you mind? British reporter
degree
towel, would
manslaughter
you
while operating
mind?
under the influence, and leaving the scene of an accident,
British reporter towel.
resulting in death.
British reporter towel, would you mind? You're being incredibly rude. I'm offended.
After a mistrial in 2024, she was
Ladies and gentlemen, just 6 minutes ago there was another strike by the U.S. in Chabahar, southern Iran. This is not a drill. I'm not going all night again, okay? I'm not. There's that hearing tomorrow. We got to be ready in the afternoon. It's going to be all busy. My point is, ladies and gentlemen, listen. There has been another strike in the past 5 minutes. I do not know if this means we are about to see an increasing round of American and Iranian attacks. However, I reserve the right to tell you should bombs just start dropping out of the middle of nowhere. I reserved that right in the beginning, and although I do love court motions, I do need to tell you it looks like America is striking Iran again. And Iran will strike back.
After a mistrial in 2024, she was retried in 2025, convicted of operating under the influence and acquitted of the remaining charges. Id. Paragraph Mark 7. Plaintiffs allege that Reed initially confessed that she was responsible for O'Keefe's death, but later changed course and began falsely accusing others. Id. Paragraph Mark 16 to 20. According to the AC, before her June 2022 arraignment, Reed falsely claimed that O'Keefe had been beaten up by
Breaking. Explosions now heard in Chabahar, Sistan, and Balochistan province. No, excuse me. The explosions were heard in Chabahar. There's more than one, and it's located in Sistan and Balochistan province. I know enough to say that. Okay, I'll keep you updated as more information comes in.
According to the AC, before her June 2022 arraignment, Reed falsely claimed that O'Keefe had been beaten up by Brian and Colin Albert, even though she knew that accusation was false because she knew she had hit O'Keefe with her vehicle. Id. Paragraph Mark 19 to 20. Plaintiffs further allege that Reed later enlisted Kearney to disseminate and amplify a false narrative that plaintiffs murdered O'Keefe, covered up the murder, and framed Reed. Id. Paragraph Mark 8, 2225. Reed used an intermediary and counsel to conceal her relationship with Kearney and preserve 1. Moreover, Reed never initiated a Rule 9c conference prior to filing this motion package. 3.
3 explosions in
Date filed
Chabahar.
the 7th of July 2026, 11:39 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Plausible deniability, while feeding Kearney non-public information and lies to publish on her behalf. Id. Paragraph Mark 23 to 25. The AC describes the public launch of the defamation campaign in April 2023, when Reed filed a discovery motion falsely accusing Brian Albert and Colin Albert of responsibility for O'Keefe's death and McCabe of being the mastermind of a cover-up. Id. Paragraph Mark 27. Reed attached an unredacted incident report containing plaintiff's private addresses, cell phone numbers, and social security numbers, and forwarded the filing to Kearney through an intermediary so he could publish the accusations and foment harassment. Id. Paragraph Mark 28 to 32. Kearney's defamatory, Canton cover-up, posts followed, and the coordination continued throughout 2023, including in-person meetings, encrypted communications, and over 189 phone calls between Reed and Kearney. Id. Paragraph Mark 32 to 60. In Kearney's initial posts, he stated that Brian Albert and Colin Albert were capable of killing O'Keefe, that Colin Albert had motive, that McCabe was the quarterback of the cover-up, and that McCabe could not have covered up the murder without law enforcement assistance. Id. Paragraph Mark 33. Kearney claimed there was a mountain of evidence that O'Keefe was killed by Brian Albert, Colin Albert, and possibly others, and that those statements were based on sources that were, in reality, Reed and her legal team. Id. Paragraph Mark 33 to 34. Thereafter, Kearney's audience exploded, giving Reed a larger platform for her defamatory narrative. Id. Paragraph Mark 35 to 36. Kearney used phone numbers made public through Reed's filing, which he received from Reed, to call McCabe and Brian Albert during a broadcast and accuse them of a cover-up, and he left Brian Albert a voicemail asking whether Brian Albert or Colin Albert killed O'Keefe and whether Brian Albert was covering for Colin. Id. Paragraph Mark 37. Kearney also displayed the incident report containing plaintiff's personal identifying information, after which plaintiffs began experiencing 4. Date filed the 7th of July 26, 11:39 p.m. Superior Court, Plymouth. Docket number 2683CV00541. Disturbing levels of harassment. Id. Paragraph Mark 38 to 39. Minutes after that broadcast, Reed's attorney, David Unetti, congratulated Kearney by text, writing that it was a great FC King show. Id. Paragraph mark 40. The coordination continued during 2023. On April 23, 2023, Reed falsely told Kearney, through an intermediary, that certain witnesses had testified to a grand jury that Colin Albert was present at 34 Fairview after O'Keefe arrived, while also stating that she could not send grand jury testimony because it was sealed.
All right, listen. Why? This is counterproductive. I get that. Karen's lawyers are so smart. They realized. No, they didn't realize. They knew that when you do an anti-slap motion to dismiss, the judge, unlike a 12b6, the judge can read your affidavits and has to weigh them when making a ruling on the merits. They forced the H.A.M lawyers to detail everything that Aiden said, which is actually like explaining the theory of the cover-up. I mean, they have to do it to counterbalance the way Karen wrote. Notice how Karen's lawyers wrote their motion, like an appellate brief. They cited 2 affidavits for every sentence because it puts a burden on the opposing party. That's why Kieran Murphy and Maddie are probably so mad, because Karen's lawyers put this huge evidentiary burden on them. It's kind of funny. But at the same time, you can tell that like the H.A.M lawyers don't really play at this level, because they're like, okay, it's such a rudimentary strategy. Let's just put all the facts in the response to the opposition to the anti-slap motion to dismiss. Let's just plead it. Let's plead the case. Okay, well, you're putting in a public court document, which I'm going to read as the opposition, all of the detail, like, cornered. It's like playing chess. You put the very information in the motion that you're just virulently objecting to. So let's continue with this. But I personally don't understand why they're doing this. I get why they have to, because of the way the anti-slap motion to dismiss works, but it doesn't help them. This doesn't give them a lot of like firepower. It just lays out Aiden's theory of the cover-up. And that's its practical effect. Let's go, British Reporter Tal. Do you want to start again? He wants to start again. So we have
Date
to go
filed
to page
the 7th of July
5.
2026, 11:39 p.m.
Thanks, British Reporter Tal.
Superior
We're going to go
Court,
down to
Plymouth.
page 5. So we're starting with the coordination. British Reporter Tal is on a little bit of strike right now. Where is it? Alright, so that's page 4. So we're actually a little bit higher. This is going to go on forever. Well, I'm monitoring the situation on the ground. There are U.S. strikes starting right now. Go ahead, British Reporter Tal. When you're
Disturbing
ready.
levels of harassment. Id. Paragraph mark 38 to 39. Minutes after that broadcast, Reed's attorney, David Unetti, congratulated Kearney by text, writing that it was a great FC King show. Id. Paragraph mark 40. The coordination continued during 2023.
Breaking. I have the footage that's just come in from Chabahar.
On April 23, 2023,
British
Reed
Reporter
falsely
Towel.
told Kearney,
British Reporter Tal, what did I say? Okay? You know, you and I, we're not having the best partnership today, British Reporter Tal. I appreciate all of your service, okay, to Towel News. But sometimes, you interrupt me. You're just, it goes a little bit too far. All right, I have the footage right now coming out of Chabahar, Iran, okay? It just happened 4 minutes ago. The U.S. has struck. Yes, this is the kind of thing you see on Towel News. We might be going through a
on
court
April
motion.
23, 2023,
British
Reed falsely
Reporter
told Kearney,
Towel.
through an intermediary,
I'm
that
gonna
certain
cut-
witnesses
well,
had
you don't
testified
have a
to a
salary,
grand
but
jury
I'm gonna
that
cut
Colin
it.
Albert was
Bad, British Reporter Towel. You're being a very irresponsible newsreader when we got breaking news coming over the wires.
present at 34 Fairview after O'Keefe arrived.
Yes, I understand. Now, I must show you this footage just coming in from Chabahar, Iran. Okay? This is what you get on Towel News. It has just happened about 3 seconds ago. I'll show you the footage live. This comes with a warning. Court documents to American bombing of Iran, which because the Supreme Leader, the departed Khamenei, Ayatollah Khamenei's funeral is over. Expect a response. Here is the explosion that has just hit Chabahar, Iran. It could be loud. It's not loud, it's actually a video of smoke. Absolutely good job, Otto. Iraq, issue rule application conclusion, 70 million bonus points to Otto. That's the result of the American attack. I don't know what we attacked. We bombed something. There's the smoke. Alright, we are hitting them hard. We're hitting them hard, Mr. President. Trump's in a bad mood. I'll get you as many pieces of... So this is what it's like. You see us hitting them, then I'll get you the footage of the attacks. But this is the first footage of the smoke. That is an American attack on Chabahar, Iran. It's a very easterly city, almost over near Pakistan. But that's what you get on Towel News. You got to be ready to go at any given moment, ladies and gentlemen. There could be, American attacks on Iran, and it just happened. The stock market's still open. Something serious is going on if Mr. President is bombing 2 hours before the close of the American stock market. Also, apparently, Israeli authorities are looking for immediate approval to launch attacks on Iran alongside the U.S. There's a situation room meeting occurring at the White House right now. Oh, goodness. I will give you a few more hours today. This motion is likely not going to be the end of our coverage. I'm so sorry, dear Towel Girlfriend. I know there's a lot going on today. I miss you. I know you're enjoying listening to this
Date
motion.
filed the 7th of July 2026.
British Reporter
11:39
Towel.
a.m. Superior Court, Plymouth.
You even interrupted my message
Docket number
of love
268.
to Towel Girlfriend. All right. Let's go. We are going down to page 5. Where's page 5? Where is it, page 5? No, that's page 15. We got to get through this document. British Reporter Towel. You got to put it on the double here because I think something bad's about to happen. Might have to start a new stream for the war, but I'd like to get through this. We put a lot of effort into this, and I want to see why Judge Gilday got so mad players to explain, why they misled him. So let's go to page, what is it, page 4? All right, there's page 1. There's page 2. Where's page 4? There's page 3. There's page 4, and we're going to start with Reed and Carney. All right, let's go.
Reed and Kearney later communicated directly, including through Signal and Exchange. More than 189 calls totaling more than 40 hours in 2023 alone. Id. Paragraph mark 52. Reed and her lawyers also met with Kearney in person to coordinate extrajudicial publications with Reed's litigation and media strategy. Id. Paragraph mark 53. After a May 3, 2023 meeting with Reed and her counsel, Kearney published a video stating that O'Keefe was murdered by Brian Albert, Colin Albert, the dog, and every other single person in that house,
Free
which included
Chloe.
McCabe and Higgins. Id. Paragraph mark 54. Kearney later accused McCabe and Brian Albert of involvement and cover-up, called the McCabes evil, and asserted that millions of people knew they had participated in O'Keefe's murder and cover-up. Id. Paragraph mark 56. Reed's counsel then appeared on courthouse steps and stated that Brian Albert, McCabe, and everyone else in the house had some level of involvement. Id. Paragraph mark 57. Continuously expressed her approval of the reputational damage caused by Kearney's publications. AC paragraph mark 74. On September 29, 2023, Reed messaged Kearney, "Look at what you've done to their reputations. And to my jury pool. Chris, Albert's business is the next casualty."
Breaking explosions. Breaking. I said breaking. Explosions reported now in Bandar Abbas, Chabahar, Konarak, Bushehr, and Avaz, Iran. I repeat, explosions reported in Bandar Abbas, Hormuzgan, Chabahar, Konarak, Bushehr, and Avaz, Iran. The stock market's still open. We're bombing the hell out of them. Hashtag America. I don't know what to tell you anymore. What are we doing? It's the middle of the day. The stock market's open. This was only happening during the war. Oh no. All right, continue. Come on, British Reporter Towel, on the double.
Around the same time, Reed and Kearney became administrators of a Facebook group that became a forum for defamatory and harassing posts about plaintiffs, and Reed posted confidential criminal case information there. Id. Paragraph mark 75. The AC also alleges that Reed made egregious defamatory statements during interviews with documentarian Terry Dunn Moira. Id. Paragraph mark 91 to 99. During her first criminal trial, Reed authorized Moira to record her trial preparation, including interviews with Reed, her attorneys, and her family, as well as conversations among Reed and her counsel. Id. Paragraph mark 91. On April 12, 2024, in Reed's presence, her attorney, Alan Jackson, verified to Moira and production assistants that Reed had told police, Colin Albert beat up John. My taillight was cracked when John was pulverized, and Reed did not deny having made those statements. Id. Paragraph mark 92. On or about April 30th, 2024, Reed told Moira that McCabe got herself into a bad mess that night and she helped clean it up, that McCabe knew John was dying and she helped expedite it, and that McCabe was a first-degree murderer. Id. Paragraph mark 93, emphasis added. In the same interview, Reed stated that plaintiffs were being federally investigated, that they know they killed John, and that she could not have sympathy for the witnesses because they are murderers. Id. Paragraph mark 94 to 95. On June 15, 2024, Reed told Moira that Higgins, Brian Albert, and Colin Albert had motives to kill O'Keefe and suggested that O'Keefe could have been struck during an escalating altercation inside 34 Fairview. Id. Paragraph mark 96. On June 22, 2024, Reed stated that she knew Higgins had a role in helping kill O'Keefe, helping get him into the snow, and helping frame Reed, while also stating that Brian Albert and Colin Albert would have enjoyed roughing John up. Id. Paragraph mark 97. When Moira raised the possibility that Reed could be sued for making such strong statements about Colin Albert, Reed responded that, if Colin could prove she was lying and that the statements were defamatory, he could sue her. Id. Paragraph mark 98. Plaintiffs allege that Reed made 6. Date filed the 7th of July 2026, 11:39 p.m. Those statements knowing they were false and knowing plaintiffs had nothing to do with O'Keefe's death. Id. Paragraph mark 99. Reed's defamatory statements did not stop there. During her 2025 retrial, Reed told reporters that McCabe's testimony was another instance of perjury and that McCabe was lying. Id. Paragraph mark 120. Reed knew those statements were false. Id. Paragraph mark 122. During that retrial, the prosecution presented footage in which Reed acknowledged the possibility that she had run over or clipped O'Keefe and that she might have some culpability as a result. Id. Reed later stated that O'Keefe entered 34 Fairview and met his demise, and that someone in that house killed John O'Keefe, referring to plaintiffs. Id. Paragraph mark 130. The harm to plaintiffs was severe and sustained. Every day since April 18, 2023, plaintiffs and their families have been harassed and tormented because of Reed and Kearney's unlawful conspiracy. Id. Paragraph mark 142. Plaintiffs have become prisoners in their own communities, besieged by people who accepted Reed's and Kearney's lies that plaintiffs are murderers. Id. Plaintiffs have faced physical confrontations and harassment at their homes, businesses, and children's activities, sustained a barrage of online abuse, and were harassed while appearing in court as witnesses. Id. Paragraph mark 144. The harassment became so extreme that the criminal trial judge ordered a courthouse buffer zone, while Kearney and his followers chanted, "Cop killers," as plaintiffs walked by. Id. The AC's claims rest on allegations that Reed directly, and through Kearney, falsely accused plaintiffs of murdering O'Keefe and participating in a conspiracy to murder him and cover up his death. Id. Paragraph mark 147 to 154, 169 to 171, 192 to 194, 196 to 200, 208 to 210, 212 to 216. Plaintiffs allege those statements were defamatory per se because they accused plaintiffs of heinous criminal conduct and were made negligently, knowingly, or with reckless disregard for the truth. Reed's motion does not answer these allegations as pleaded in the AC. The motion lists only a handful of Reed's statements from the earlier pleading and seeks dismissal based on count numbers and paragraph citations that do not match the AC. CMOT at 3 to 4, 7 to 14, 19 to 29. Most significantly, although the AC alleges for the first time Reed's direct statements to Moira in paragraphs 91 through 99, Reed's motion does not include those statements in its description of the defamatory statements at issue and does not argue why those allegations fail under Rule 12(b)(6) or the anti-SLAPP statute. Id. That omission is a dispositive concession and confirms that the motion should be denied. 2. Argument. A. Reed's special motion to dismiss pursuant to GL Circa 231, Section 59H must be denied. The anti-SLAPP special motion to dismiss is a strong medicine. Bristol Asphalt Company, Inc. vs. Rochester Bituminous Products, Inc., 493 Mass. 539, 555, 2024. Offering powerful procedural protections, the statute is only to be employed in a limited context. Id. Because of its limited nature, the Supreme Judicial Court, SJC, recently returned to the necessarily narrow and strict construction of GL Circa 231, Section 59H outlined in Duracraft Corp. vs. Home Products. Corp. 472 Mass. 156, 1998, Requa, Ing. Courts to proceed cautiously when considering anti-SLAPP special motions to dismiss. Id. At 554. Throughout its analysis, the Court shall consider the pleadings and supporting and opposing affidavits stating the facts upon which the liability or defense is based. G. L. Circa 231, Section 59H. The standard of review is fundamentally different from a Rule 12 motion because it incorporates additional fact-finding beyond the facts alleged in the pleadings. Sheehan vs. Town of Carver, Ma. 2026 WL 821889 at *7, D. Mass. March 25, 2026, quoting S. Middlesex Opportunity Council, Inc. vs. Town of Framingham, 2008 WL 4595369 at 10, D. Mass. September 30, 2008, internal quotations omitted. 8. For her special motion to dismiss to survive the first stage of the court's analysis, Reed must show that the challenged count has no substantial basis in conduct other than or in addition to her alleged petitioning activity. Bristol Asphalt, 493 Mass. At 555 to 56. If she cannot make the requisite threshold showing, the special motion to dismiss is denied. If the threshold showing is made, the second stage of analysis follows. Id. At 556. Courts cannot pass the factual allegations underlying each claim to determine whether a portion of the plaintiff's cause of action could be construed as being based on Reed's petitioning alone. Id. If this court were to determine that even part of a claim is based on Reed's substantial conduct other than or in addition to the petitioning activities, the special motion to dismiss must be denied as to that claim. See Hanamura vs. Newton, 104 Mass. App. Court 1108, at *4, 2024, unpublished, quoting Bristol Asphalt, 493. Mass. At 554 to 556, see also Ehrlich vs. Stern, 74 Mass. App. Court 531, 536 to 37, 2009, citing Duracraft, 472 Mass. At 167 to 68, T. The anti-slapping inquiry produces an all or nothing result as to each count. Dot. Dot. And the statute does not create a process for parsing counts to segregate components that can proceed from those that cannot. If the court reaches the second stage of analysis, plaintiffs must show that Reed's exercise of her right to petition was devoid of any reasonable factual support or any arguable basis in law, and caused actual injury to the special motion opponent. Bristol Asphalt, 493 Mass. At 557. Quoting GL circa 231, section 59H. Mixed claims, based on a proponent's petitioning along with substantial conduct other than or in addition to the petitioning activities, inevitably involve an inquiry into both sides' legitimate petitioning rights. Id. At 555. Thus, unless Reed can show that her activity was for the purpose of petitioning alone, which she cannot, the parsing of claims involving a mixture of petitioning and other matters is best addressed in the course of ordinary litigation, where both 9. sides' claims and defenses can be fully analyzed based on a more complete record, not special motions to dismiss. Id. For the following reasons, this special motion to dismiss must be denied. I. Plaintiff's claims against Reed are not based on petitioning activity alone. The AC alleges extensive non-petitioning activity undertaken by Reed, including allegations that her motion fails to address at all. That non-petitioning activity, which Reed largely ignores, includes, but is not limited to, 1. Defamatory statements to a documentarian, 2. A course of defamatory, harassing, and intimidating conduct that she jointly pursued with Kearney, 3. Defamatory statements that McCabe committed perjury, and 4. Defamatory statements that the plaintiff murdered O'Keefe. Some of this non-petitioning activity was criminal in nature. In post hoc fashion, Reed now offers a subjective, self-serving motive for her defamatory conduct that should not be considered by this court. Reed failed to object to the operative complaint. Reed's motion incorrectly asserts that plaintiffs identify only a handful of allegedly false statements by Ms. Reed about plaintiffs, MOT. At 7. Among the many allegations that Reed ignores are the newly pleaded statements Reed made to Moira. See generally, MOT, AC paragraph mark 91 to 99. Those allegations include direct accusations that McCabe is a first-degree murderer, id. Paragraph mark 93, that plaintiffs know they killed John, id. Paragraph mark 94, that plaintiffs are murderers. Dot. And they know it, id. Paragraph mark 95, and the plaintiffs played a role in O'Keefe's death, id. Paragraph mark 96 to 97. Reed even asked Colin Albert to sue her if her actions were defamatory. Id. Paragraph mark 98. These allegations are central to the AC and are ignored by Reed's motion. Having failed to address the operative allegations, Reed has waived any request to dismiss the AC. See, e.g., Yong Lee v. Huffman, 2012 WL 462828, at asterisk 1, D. Mass. January 3, 2012, citing Connect ULLC v. Zuckerberg, 522 F3D 82, 91, 1st CIR. 2008, p. Leadings directed to the earlier 10. Complaint or a nullity. A defendant must file a pleading in response to the amended complaint. Charles Allen Wright and Arthur R. Miller, 6 Fed. Prac. And Proc. Section 1476, 3D ed. 2005, I, F. the 1st. Complaint is considered superseded. The court is not required to dismiss the suit when a motion points to the weaknesses of the earlier pleading. Point 2. B. The AC alleges that Reed engaged in non-petitioning activity, and Reed fails to demonstrate otherwise. Fundamentally, Reed's argument rests on the false premise that a criminal defendant may falsely accuse others of murder and surreptitiously conspire to do so, with impunity by later arguing that it was all petitioning activity. Of course, Reed is incorrect. See Burley v. Comet CMTY. Youth Center, Inc., 75 Mass. App. Court 818, 823, 2009, reasoning defamatory statements made to members of public and not intended to facilitate further consideration and response by the police do not constitute petitioning activity. O'Gara vs. Saint-Germain, 91 Mass. App. Court 490, 495-96. 2017, explaining protections covered by GL circa 231, Section 59H are limited to expressions in which a party seeks some redress from the government, Glob. Naps, Inc. vs. Verizon New England, Inc., 63 Mass. App. Court 600, 607, 2005, holding the statute does not protect tangential statements intended, at most, to influence public opinion in a general way unrelated to governmental involvement. She cites no authority for this proposition, which would overturn centuries of defamation law in this country. See Draghetti vs. Chmielewski, 416 Mass. 808, 812, 1994, imputation of a crime is defamatory per se. Stone vs. Essex County. Newspapers, Inc., 367 Mass. 849, 853, 1974, same, Friedman vs. Connors, 292 Mass. 371, 374, 1935, same. Moreover, the AC expansively alleges that Reed pursued a course of conduct that did not seek redress from any governmental authority but, rather, harassed, intimidated, and defamed. 2. And Reed cannot raise new arguments through her reply. C. E.g., Com. Versus McGowan, 400 Mass. 385, 390 N.4, 1987, we need not pass on grounds. Dot. Private individuals in service of Reed's personal interests. Simply put, Reed's years-long campaign to defame and intimidate witnesses in the prosecution against her, which included defamatory statements to a documentarian and others, her use of Kearney and others to launch defamatory attacks against the plaintiffs, and her conspiracy to harass and intimidate the plaintiffs cannot constitute petitioning activity. Reed ignores the AC and wrongly claims that the plaintiffs allege only 6 instances of defamatory conduct, all of which she argues constitute petitioning activity. In doing so, Reed not only fails to establish that those 6 allegations constitute petitioning activity but completely fails to make the requisite threshold showing that Count 1 relies exclusively on that conduct. Reed would have this court believe that Count 1 is based solely on 1. Reed's initial false report to law enforcement that Brian and Colin Albert beat up O'Keefe. 2. Reed's false statements in a court filing. 3. Reed's subsequent transmission of that filing to Kearney. 4. Reed's mischaracterization of grand jury testimony to Kearney. 5. Reed's extrajudicial statement that McCabe committed perjury. And 6. Reed's extrajudicial, post-verdict statement during a podcast that the plaintiffs killed O'Keefe. MOT. At 7 to 8. Even a cursory review of the AC demonstrates that Reed's conduct extended far beyond these cherry-picked examples. In a recorded conversation with a documentarian, Reed stated that McCabe was a first-degree murderer, the plaintiffs, no, they murdered O'Keefe, and the plaintiffs were murderers. AC paragraph mark 94 to 95. Reed doesn't address these allegations at all, nor could she established that these statements constitute petitioning activity where she made him to a documentarian with no expectation that the statements would be transmitted to a governmental body or released in a manner that could plausibly implicate a governmental proceeding.
Wait a minute.
C.
Wait a minute. What if that documentarian was a plant and was actually working for the state? What if she didn't have a falling out with Karen? What if the whole thing was a setup? I hope that these plaintiffs realize what they're doing by arguing this. If they use that documentarian to get information from Karen in a way that was going to be used against her but she didn't know and it was surreptitious, listen, Karen's own lawyers described it. There's a limit to what you can do. Even if you're not, quote, hired as private intel, if you're working through a subsidized private intel operation, and you do stuff like that to get evidence, listen, it's not as bad as, say, like, just hypothetically, pretending to like someone so you become their romantic partner, and then you get close to them, and then you steal their entire phone extraction and release it, and then try to get that into the public so it can be used as the basis in a civil trial. You know? Because under the Fourth Amendment, that would not be, or a criminal trial, that wouldn't be permitted at all. But if you evidence launder, you know, well. This case has a lot of information, all these cases. You got to ask the right questions of the right people. They flooded the zone, literally, to keep people from being able to see what was going on. It all was an operation to get derogatory information on Karen and Aiden to then launder the information, in my opinion, into these kind of pleadings.
C. Blakesley versus Marcus, 158 F 4th 90, 99, 1st CIR.
Yep. Tower girlfriend they were.
2025. T. Here must be a plausible nexus between 12.
Yes, British reporter Tower,
Date
go
filed the
ahead.
7th of July 2026, 11:39 p.m. Super. The statement and the governmental proceeding, quoting Blanchard versus Stewart Carney Hospital, 477 Mass. 141, 149, 2017, overruled on other grounds, Bristol Asphalt, 493 Mass. At 556 and N.17. Likewise, Reed utterly fails to reckon with the extensive allegations detailing her conspiracy to use defamation as a tool to intimidate and harass the plaintiffs. The AC alleges that Reed conspired with Kearney to publish defamatory material, in part, for the purpose of intimidating and harassing the plaintiffs and their families. CAC paragraph mark 19 to 78. Reed makes no effort to justify this conduct, some of which was criminal, as petitioning activity. Indeed, conspiring to defame witnesses in order to intimidate them and jury tamper is not petitioning activity because such criminal acts target private individuals and are not undertaken to reach governmental bodies. See Sexual Minorities Uganda versus Lively, 960 F sub. 2D 304, 328, D Mass. 2013, the petition clause cannot protect activities taken for unlawful purposes or toward unlawful ends, citing Cal. Motor Transport. Co. versus Trucking Unlimited, 404 US 508, 514, 1972, Blakesley, 158 F 4th at 99, explaining courts look to objective indicia of a party's intent to influence a governmental proceeding, such as the timing, audience, and content of the statement, quoting Blanchard, 477. Mass. At 149. Reed herself embraced the impact of Kearney's criminal conduct when she messaged him, "Look at what you've done to their reputations. And to my jury pool." AC paragraph mark 74.3. To now suggest that destroying a witness's reputation and tainting a jury pool is petitioning activity is preposterous. 3. Massachusetts courts have already found that Kearney's conduct, which the AC alleges he jointly undertook with Reed, was likely criminal. For example, in denying Kearney's attempt to vacate a no-contact order in November 2023, Judge Krupp explained that, in pursuit of his performative journalism and personal brand, Kearney has berated witnesses in the Reed case, badgered them, and pressured them to change their testimony.
Now, is that... Now, listen. You know, I know we got a couple things to do. I want to... First of all, we're at page 13. How long is this? Oh, come on. We're not even halfway through? No. Oh my goodness. You wrote a 26-page opposition? Oh my god, it's longer than 26 pages. Oh my god. You wrote... First of all, is this longer than your initial complaint? You wrote a 30-page opposition? I'm not reading all of this. Are you kidding me? We'll be here till 6 o'clock. Are you kidding me? But wait a minute. I'm seeing a lot of stuff that's weird. Because, that name, Judge Krupp, it rings a bell. Sometimes people just make rulings I think are weird. But sometimes, it's a vibe. All right? Now, everybody's different. All right? Some people are just sticklers for the rules. But, that ruling by Judge Krupp, I'm wondering, who's going on there? And let me just tell you what. Now, I'm just a little town. And, hey, Joy, it's so good to see you. Joy, I sent you an email, my dear friend. You're wonderful. Let me know if you got it. I think it should have come in. It might have gone to spam, though. I don't know. I did use my Gmail. I just want to make a point here. I'm seeing a pattern where a lot of the evidence being used against Karen and Aiden. First of all, did you notice that Aiden's statements imputed to Karen are most of the complaint? A little bit of what Karen said in some of her interviews, but the reality is, where does most of this come from? What Aiden was saying. So it's almost like Aiden wasn't involved. I think Aiden was just being Aiden, wound up and kind of let go on the situation. But I think Aiden and the documentarian, in different ways, were both used, although Aiden ended up helping Karen, I think the documentarian was designed to hurt her, but Aiden was also used to hurt Karen, although not the same way, not intentionally. More like just use his existence as a way to hold Karen accountable for what he says, and Karen didn't see it. So that seems a little calculated. And then the Judge Krupp ruling about Aiden's criminal case, because remember, Aiden did a motion to dismiss. Now, why do I say it's weird? Well, because there was just something off about that ruling. So, not that Judge Krupp has made, always bad rulings. He did some things, I think, eventually, but it almost felt like he only did a few good rulings. I mean, there was, one, because he knew it was, getting bait. But yeah, let me just take a look here. I think, let me see if I have the documents here. Where are they? Where are they here? Where is it? Oh, yes. Is it this Peter Krupp? Hold on one second. Yes. Is this it? Oh, British Reporter Towel. I'll give you a little bit of a break from motion practice. But Peter Krupp, is this the same guy? Let's just take a listen. Go ahead, British Reporter Towel. This was from, February 6th or so? When was it? February 3rd, 2026. Right after the Epstein files came out. Go ahead, British Reporter Towel, whenever you're ready. Because now Judge Krupp's ruling is being used against Karen and Aiden in a civil trial. Just like the stolen phone extraction, I'm sure will try to be laundered. Just like the documentary interview. There's just some weird stuff going on. So let's take a listen. Go ahead, British Reporter Towel.
Conversation. Semicolon. Peter Krupp, the judge who is currently overseeing the potential search warrant for Karen Reid's phone, and the judge who sat on S case until last month, is in the Epstein files from 2010 as an investor in one of Epstein's companies, Green Jets. Right as Krupp was representing a Russian spy. Epstein files source document, page 2 of 7. More context on Krupp working as a lawyer for a Russian spy at the time. Krupp also appears in the files in the context of a lawsuit between Epstein and Scott W. Rothstein, an American former lawyer, convicted felon, and the former managing shareholder, chairman, and chief executive officer of the now-defunct Rothstein-Rosenfeld-Adler law firm. Source document for record search on Peter Krupp as part of a lawsuit between Epstein and Rothstein, page 20 of 40. That lawsuit, related to Epstein abusing underage girls in Florida in the 2000s, was settled just months before Epstein's 2019 arrest on federal charges. Epstein had avoided jail in 2008 with a sweetheart deal. Source as to lawsuit settling and more background, via CNN. Interestingly, Rothstein was a powerful lawyer who helped select judges in Florida before getting caught running the following scheme in 2015. Lawyer David Bowden, who would serve 18 months for his part in the scheme, was present for some of the swindle pitches and negotiated the final papers with the investors' lawyers. He stated that Rothstein would tell investors that RRA was the preeminent sexual harassment law firm in the country and said that he'd figured out a basic formula through which, for example, someone with a net worth of $10 million was willing to pay $2 million in cash to pay off their mistress. The key was the promise of confidentiality. Rothstein said that he would meet potential defendants and question them about affairs they had with any employees. The defendants would deny any such affairs. He would point to a piece of artwork on the wall, say that there was a television screen behind it, and tell the investor that he would show the defendant a video of him having sex with his mistress. He said that he would say to the defendant, "We can either settle this now, or I can depose your wife, your mistress, you and your son about it," since defendants often couldn't or wouldn't pay the entire settlement up front. Rothstein told investors that his first harassment case involved a $3.5 million settlement and a $1 million legal fee. Rothstein said that he assigned the settlement to a friend and the plaintiff settled for $3 million without going to trial. Read more here, source. In 2018, Epstein settled the lawsuit he filed against Rothstein, just 6 or so months before Epstein's arrest. It appears Epstein was pressured by Rothstein's firm in the early 2010s, then Rothstein caught federal charges in 2015, then Epstein settled with Rothstein in 2018, after some serious names started to leak in Discovery, then Epstein was arrested himself in 2019.
We'll wait till the frame drop settles. I can wait.
Peter Krupp, for his part, seems to be a name that was dropped in that lawsuit because of Krupp's investment in one of Epstein's companies as part of some high-stakes political game in the lead-up to Epstein's 2019 arrest. Krupp's most recent financial disclosures, from 2024, do not reveal holdings in Epstein's Green Jets company. However, Krupp has an expansive investment portfolio. On Monday, I reported, following a weekend of hell on earth. Breaking news. Jeffrey Epstein and Ghislaine Maxwell used a charity called Learning for Life to formally contract with former Stoughton Police Deputy Chief Robert Devine in order to run programs for children in Norfolk County coordinated by District Attorney Michael Morrissey. Robert Devine was involved in the Sandra Birchmore cover-up and may have been Jeffrey Epstein's point person for a Gestapo group of state and local police in the Commonwealth of Massachusetts who operated brothels. Girls, in line by any means necessary, forced addictions, threats, fake criminal charges and, if necessary, murder. Quoting crime timelines. The Stoughton Police Department ran the Explorer program for about 15 years, but could only locate a single one-year agreement with Learning for Life, the scouting affiliate that oversees the National Explorer program. Robert C. Devine has led the Stoughton Police Explorers program since 2003, a youth initiative under the department. Source for Devine's contract with Maxwell and Epstein's Learning for Life conspiracy. Interestingly, new Epstein files confirm that Ghislaine Maxwell visited Stoughton for the first time in 2006, right as Devine was starting his chapter of the Learning for Life conspiracy. Find confirmation that Maxwell and Epstein ran Learning for Life, and all of its associated programs, including basketball camps, baseball camps, and otherwise for young children in the Norfolk County area, here. In any event, state officials have been contacted. I am working to immediately end all of these programs. I will have more information shortly. Earlier Monday, I reported. I've confirmed that Jeffrey Epstein, Norfolk DA Michael Morrissey and Robert Devine, all three men potentially connected to a cop-run brothel in Epstein's network that used the state police in Massachusetts to enslave victims, were in Stoughton on July 8-9, 2014. Read the primary source confirming Epstein's presence in Stoughton on those days here. Read the post confirming Devine, the potential point man for Epstein and Maxwell's operation in Stoughton since at least 2006, was in Stoughton on that day for a young basketball camp. Devine used to run the basketball camp for kids in question before it was taken over by Morrissey. And Devine was involved with the Police Explorer program wherein Sandra Birchmore was groomed, potentially brought into Epstein's brothel and then killed when she wouldn't stay silent, a crime then covered up by the Norfolk DA's State Police Unit, here. Strangely, although the camp was run and attended by Morrissey for multiple years in the summer around the same dates, there is no press release on the Norfolk DA's website covering the July 8-9th, 2014. Camp in Stoughton, the very days Epstein was in Stoughton according to Epstein's bank records. Every other year is listed here. As a result, the ex-post linked above, from July 9, 2014, is the only record in existence of the camp, although the Norfolk DA can clearly be compelled to turn over any material related to that July 8-9, 2014. Camp involving Robert Devine and Michael Morrissey, via the Public Records Law, but I am also not a lawyer and this is not legal advice, I am a towel. That link, again, for the record is. Ghislaine Maxwell, for her part, was in person in that area as early as 2006, perhaps to set up Epstein's brothel and assign Devine as the regional pimp of all pimps. Source, page 12. Late Sunday, I reported. There was something called the MSPB-FIT team that links together a number of men, including the former colonel of the state police, who may well have been involved with Jeffrey Epstein's operation out of Stoughton, Massachusetts as enforcement wing of Epstein's cartel. The names are follows: Colonel Christopher Mason, Major Joe King, Captain Lenny Coppenrath, Detective Lieutenant Mark Sear, Sergeants John Fanning, the MSPB FIT team captain, Vincent No and Brian Tully, as well as troopers Joseph Cords, Yuri Buchanek, Jeff Kopkaski, Sean Quirk, Daniel Santa, Anthony Pereira, and Catherine Lamb. It seems that almost all of these men, spanning the State Police Command and the Norfolk DA's SPD-UMSP unit, will show how connected to Robert Devine and a ring of police who were targeting young girls, grooming them into a brothel and then strong-arming those women into staying silent for life, via trumped-up criminal charges or, in some cases like Sandra Birchmore, murder. Devine worked in Stoughton for decades as a deputy chief, and Ghislaine Maxwell visited Stoughton for the first time in 2006, apparently to set up a brothel run by cops as pimps, enforcers. John Fanning, the trooper who, in 2021, wrote the report covering up Sandra Birchmore's murder, also worked in Stoughton as a cop before going on to work at the Norfolk DA's MSP unit, as did Yuri Buchanek. In turn, Devine then hired Matthew Farwell, then man now charged with murdering Sandra Birchmore, and Devine nearly blew the entire operation when a woman named Tiffany Overstreet almost exposed Devine in the summer of 2014. Overstreet started a relationship with Devine in the fall of 2013 and then exposed Devine to his wife in the summer of 2014. Interestingly, Epstein personally paid a visit to Stoughton on July 9, 2014, and, within months, Overstreet was targeted by Norfolk DASPDU trooper Sean Quirk, who, in turn, worked closely with Robert Devine to arrest Overstreet in the fall of 2014. Charges that were then dropped in the spring of 2015. To his credit, was the first person to figure this out. Brian Tully, for his part, took command of the Norfolk DA's MSP unit and was involved in directly supervising Yuri Buchanek, Jeff Kopkaski, Sean Quirk, John Fanning and others during the time period when the Birchmore cover-up occurred, in 2021. Tully's MSP unit, in turn, was also involved in both the Karen Reed and Turtle Boy prosecutions, and, it seems clear to me now, that the MSP Norfolk DA's unit was part of a splinter cell within MSP that served as a private army and prosecution force for Mr. Epstein, and Turtle Boy and Karen Reed helped the DOJ, including Adam Deitch, expose them all. In short, Massachusetts, meet your modern INTERPN, and, yes, it is that bad, if not worse.
So yeah, I'm just telling you, nothing is as it seems. I can't do 30 pages of this. One, because I have no idea what's about to happen in the Middle East. Two, I understand now why Judge Gilday is concerned, because in the initial part of the motion, the Karen's lawyers argue Karen's lawyers argue that the H.A.M lawyers argue that Karen didn't properly file the motion. So, like, pursuant to Rule 9A, they didn't do a 9C conference. You look at those emails. The Judge Gildea looked at the exhibits, and it's very clear. Ladies and gentlemen, Joy has just announced that Tal will very soon be, I think I know the date, we'll wait for Joy to announce it and others. Tal will be a guest on Justice Served TV. I'm very honored and excited. It's going to be great. I can't wait to see it. I'm so excited. Tully, 3 Clerk Monty says, reported to Coppenrath on the management of Karen's case, securing experts to support Trooper Garino's finding. Yeah, wonder how Trooper Garino's doing. I hope he's well. I always wondered how that drunk driver hit him, you know? That was a little weird. I'm not really sure he was supposed to live. I'm glad he lived. I hope the feds have talked to him. You know, I kind of feel like he might know some things about the cover-up of Sandra Birchmore's murder and the cover-up of John O'Keefe's murder. I feel like out of everyone in the world, Nick Garino's a good person for the feds to talk to. That's just my opinion. I don't know nothing about nothing, though. I don't even know who any of you are. But in any event, John O'Keefe, of course, was working for the highly secretive Boston Police Sex Offender Registry Unit, who is known for doing undercover investigations around the state. So, make of that what you will. John O'Keefe also confronted a drug dealer outside of his home. Karen filmed it with John. They sent it to Kevin Albert. Wonder who that drug dealer was working for. I heard Epstein was running an op that was a bit of both. For the general public, which was basically cops and firemen and DAs and judges. For the general public, drugs, like party drugs, and girls. You go to the restaurant, you order the girl off the menu, and then you go to the back. That's generally what I understand was happening, okay? And then, I think it was, like any operation, okay, it was a little bit of, do it by the books, if there's even such a thing as the books for that kind of op. And then a little bit of like, hey, like, what was that guy's name? Roy DeMeo? Roy DeMeo went a little overboard. And I'm not talking about just the bodies and the way he would kill people in the Gemini Lounge. I'm sorry to be vulgar. Roy DeMeo was trafficking children. Like, very obviously. Very, like people were mad about this. The powers that be were very mad. You can't do that. Okay? It was very dishonorable. You're starting to wonder if maybe, like, the general public, the patrons of these brothels, got, like, the, like, girls, the 18 to 30-year-olds, right? And you're starting to wonder if maybe there was another group, some kind of, like, high priestesses, demons. Who the hell knows what the hell these people do with their lives? Frankly, I don't want to know. All right? It seems to involve some kind of Baal worship, something named Moloch, some kind of owl, checkerboards, like the self being God, no external God. They're very weird, like Neo-Canaanites, basically. They're really like Neo-Assyrians or like Neo-Babylonians. It's odd. It's like it predates Egyptian religion. It's this like odd form of religion, if you can call it religion. I call it more like hedonism. Like, what's the word? Heresy might be a good word for it. It's the type of people the Torah talked about as being really evil, like the worst of the worst. It's the type of people Jesus drove out of the temple with a bullwhip. All right? It's the type of people embodied in the Holy Quran story about the Pharaoh. Okay, you ever read the Holy Quran talking about the Pharaoh? Listen, you can learn a lot about it. My dear Muslim brethren and sisters were kind enough during the war to teach me and allow me to read about the Pharaoh on stream. It's like the Pharaoh combined with the people Jesus was driving out of the temple, which was one of the last things he did before he was crucified, by the way. Okay? And what the Torah talks about as like the worst of the worst. If you read the Torah about the Canaanites, it says in no uncertain terms, these people are like the most dangerous human beings on earth. Seriously. They do terrible things. I think they're still around. It's a small group, from what I can see, maybe like 10 to 20,000 in the U.S., maybe bigger, maybe less. I can't really tell. These people are not the run-of-the-mill firemen, cops, even state detectives or line prosecutors or what judges. These people are like the shadow people, like the people who make a lot of money and like hide in plain sight but have security clearances, just speaking very broadly, that kind of person. Or somebody who like, walks around on the streets of New York in a bathrobe pretending to be crazy but is not so crazy. I think some of these guys and girls get access to something else, okay? And I think that's what Epstein was all about. Like, I think they get a taste for younger victims, okay? That's my opinion. I don't know. I'm not speaking about anyone particular. Clearly, Epstein did. But I think what people don't talk about is what Epstein was doing. He thought of himself as like a king, okay? Running this network of people who he thought were like him. Okay, what that really meant was he knew they abused kids. Okay, which meant when he came asking for a favor for his network, you did it. And that's what I think this was all about. And it goes way deeper than Jeffrey Epstein and Adnan Khashoggi. I want my damn paintings back. He stole them. Adnan Khashoggi's man, Daryl Nitke, stole them in 1990. He got the idea from Miles Connor. They were going to try to leverage it to get a lower prison sentence for Adnan Khashoggi. Then he got found not guilty, so they didn't need to. Then they just stole my frickin' paintings. They belong to the people of Massachusetts. I'm going to find them. But, I think it's not Adnan Khashoggi. It's not Jeffrey Epstein. It's this kind of, I'd call it exoteric versus esoteric dichotomy that's defined the story of human civilization. You can take individual cases as examples of good versus evil, but the actual sort of battle over the ages has most certainly been between like this very like disgusting group of people that are afraid to advance their true beliefs and carnal interests in public. So they put on the ostensible veneer of, like a doctor or a lawyer or some other guy, and they walk around like everybody else, but when they like put the mask on at night, like they do terrible freaking things, and it's not gratuitous. They're not just hedonists. They're doing terrible things in the service of blackmailing other people who they do the terrible things with to perpetuate this clique, this ruling clique. And I think it is all in the service of kind of like worship of the occult. Not like the occult in the pagan way, like people who like trees. More like Baal. And not just Baal, but like Moloch. Like these very specific demons that like people, that will give people temporal power in this weird belief structure if they like hurt kids. And like give the kids over to the demon. And I also think they get sort of like sexual gratification because they seem to think, I'm just speaking generally, this Epstein group and those people around him, that the reason the rest of society doesn't hurt children is because there's a law against it. They seem to get off on this idea that like they're doing something that other people can't do because there's a wouldn't do that, Pause, frame drop, pause, we're back. They don't realize it's wrong and people wouldn't do that. So they're doing something gratuitously immoral, getting off on the idea that they're doing something other people want to do but can't do when other people don't want to do that to begin with. So there's just a bunch of powerful people who are freaks and very evil that do evil things together and then go around feeling high and mighty off it, okay? And I'm sure they do weird drugs too that we don't even know about. I don't even want to think about it. Okay? And then they're like, those damn peons. Like, we're not even going to let our eyes rest upon them. When we sit in our social clubs, we'll sit in a chair and look at a mirror, and then we'll look out the window, and that's the only way we can look outside. They really do this. Don't ask too many questions. The point is, that's what's going on here. And these people need to go, all right? They need to leave the United States. If you've hurt kids, if you worship Baal or Moloch or any of that weird, I'm not saying religion is weird, okay? People have all sorts of views. But if you worship evil demons, like, let's just be very clear. Or if you've hurt kids, you got to go, all right? You can't stay. You got to leave the United States. We're not putting you on an island, all right? I don't trust any of you on an island. But you got to leave, all right? So that's my lecture for the day. Yeah, Eyes Wide Shut was really good. I think that was the Kubrickian kind of warning. And listen, I don't know why it takes people like me, all right, and Kubrick. I'm not a Kubrick, okay? He thinks in paintings. I think in, like, historical concepts, I guess. Like, I just see timelines of events, okay? I don't really think in art. He thought in paintings, like abstract paintings. But I guess there's something about, like, so for example, Kubrick got in trouble when filming Dr. Strangelove because his replica of the B-2 Stratoforce bomber was so accurate they thought he stole classified documents. He was like, no, dude. Like, I just looked at footage, talked to people. Like, I just researched it. And they were like, you researched it? I was like, yeah, I researched it. And they were like, oh, well, maybe you like should come over to the U.S. Do you want to like come down to some of our test sites? You really should come hang out. And then, NASA went over to hang out with him. I think they just wanted to learn about how he made 2001: A Space Odyssey, Anyway, don't ask too many questions. So the point is, like, I think you get around powerful people. Kubrick more by his own, like, gusto. Orson Welles by happenstance. Me, I guess, by happenstance. And just being a towel. Not just where I was born and who I was born to, but just like what I would do in life. I just would find myself around powerful people in government and just talk to them. Then I got a lot of friends. Anyway, my point is, I think there are some of us who just don't play ball with that whole system. Like, we were meant for it, but then at a certain point, that system was like, dude, if we bring them in, they're going to destroy it, so we can't bring him in. Yeah, good call. It was a really smart decision for them not to bring me in, because one, I wouldn't have played along with it. I probably would have, like, ran down the street screaming. Like, if I ever saw anything directly, that was a serious, serious problem. So I think they were like, let's just keep him like on the periphery. Let's just not tell him. It's probably for the best. And maybe I didn't get to go to like whatever weird things they were doing, but that's for the best. Something definitely happened to me when I was a kid. I don't know when. I'm still trying to figure it out. Like, I looked at some baby pictures of baby towel when I was a washcloth. I just had this light in my eye. I forget, I was showing Towel Girlfriend or something. And I just had this light in my eye as baby towel. And then something happened, and I don't remember a lot for a lot of years. And then when I came out of it as like a teenager, the light was gone, and it never came back. But my point is, for like 15 years, I was unreasonably afraid of the dark and also needles. And I still don't know why. So, yeah, I'm going to figure it out. I think, from what I understand, it's like a lot of... I don't want to go too deep into it, but I have some ideas of what might have happened and why I don't remember it and things like that. Because I've just heard some talk. But it really bothers me. Because I have such like a refined memory sometimes. But yeah, in terms of my childhood, no. Nope. So, yeah. But also, I've heard that these gifts, I was reading the Epstein files. Apparently, when you have gifts like this, and you can like remember a lot, talk a lot, and you're smart, it's like when trauma happens at a young age to a child, and the child perseveres through the trauma, they can come out the other side with certain levels of gifts. This was how Epstein was studying it. And so I don't know what happened to me or why, but I've always had these gifts. And I always thought it was normal. I was reading Black Mass when I was like 11. I used to read Supreme Court cases like in middle school, and I was very confused as to like why the other kids, like I liked Garfield, the show on Fox 25, the cartoon. I liked WWF, but I didn't understand like why the other kids didn't want to talk about like, you know, like page 58 of Webster's dictionary. I was very interested in anti-disestablishmentarianism. And I was like, well, don't you want to learn about like why there was a movement to oppose the disestablishment of the, you know, Anglican Church in England during the Civil War? And my classmates who were like 11 would just look at me like, what? And then they would just kind of be like, no. And they'd be like, oh, okay. But anyway, so it must have happened before then. Because, yeah, I remember this started probably when I was like 10 or 11. And I've been this way ever since. I got so frustrated in high school. And I got so bored. I didn't understand why we had to go so slowly. I was so bored all the time. I felt very out of place. Now I feel very in place. Now I'm doing what I like to do. But yeah, I don't know. Apparently Epstein was studying these like levels. And that's why I'm a little worried. I'm just worried about a lot of things during my youth. Especially like the orbit I was in. I never thought it was weird to just be around very powerful academics. You know. But now that I think about it, you know, I'm a little worried I escaped the, what's it called? If we were talking about this in Matrix analogy. You know that little like the pods of humans. I might have escaped. I think I was supposed to be in a different role, and I just kind of broke free. Yeah. So, now you have me. I think there are other people like me, but the reason you never see them in public doing this kind of stuff is they get caught up in the machine. And once you're caught up in the machine, once you get caught up in the machine, you can't come back. You know, Mr. President said, once you go communist, you don't come back. Once you sell out, you never come back. All right. I got to pause. Okay, we're not doing the rest of this now. I have to pause. We're not doing 30 pages. Once I saw them, I got the point of what they were doing and how they did it. Now, what's shocking is I'm now hearing the attacks on Iran right now are not by the U.S. I repeat, the attacks on Iran right now are not by the U.S. Repeat. In a move that could put a substantial number of countries in harm's way, the attacks being launched right now on Iran are not from Israel or by Israel, and they are not by the U.S. So that seems like Qatar, Bahrain, UAE? No, not Israel, my dear towel girlfriend. Alright, we're closing up this stream. You might see me live for a few more hours tonight. Something's inevitably about to happen. I do not think it was Israel. From what I understand, this might have been the Gulf states. No, the Kurds don't really have airplanes. These were airstrikes, so I'm thinking Qatar or Bahrain. It seems more likely to be Kuwait and Bahrain, both of which have Air Forces A and missiles. Okay, so we have right now, I do not know who for the first time during this war. Not that this was a war stream, this was a document stream. We learned what we needed to learn, trust me. For the first time during this war, I do not know who just struck Iran. It apparently is one of the Gulf states. They have just bombed Iran. And I repeat, it is not the U.S., and it does not appear to be Israel. Wow. And I don't know who did it. All right, this is Pete Bunny Towel, by the way. He's the channel mascot. Thank you so much to everyone who supported Towel Channel. I'm going to go for a walk. It's very hot where I am. It's actually about 89, 90 degrees Fahrenheit. But I need some air. You might see me again. I think you will get a short war stream, but I'm not staying up all night again. I was so tired and delirious this morning. God bless all of you, but it was important, I think, to cover it. I think tomorrow is likely going to be the day. Tomorrow at about 4:30 p.m. Eastern, okay? So I will go live. If you don't see me today, because I'm literally exhausted, you will see me between 2 and 4:30 p.m. Eastern tomorrow, Friday. Why? Because there's the Karen Reed hearing at 2, okay? I think it's going to be covered. I will speak to the pool. I think there will be a live stream. It's supposed to be 100 degrees. I'm not doing that trip again. Thank you all for that staycation. I'll go see Towel Nana again very soon, but I'm not doing that again. I think it's going to be live streamed. I'll talk to the pooler. I'll get you an update as soon as I can. We're all in the same pool, the media, so I can find out if they're going to have a live stream and a camera there. I'll get you an update as soon as I can. No matter what, Ayatollah Khamenei, the departed supreme leader of Iran, his funeral ends tomorrow, ladies and gentlemen. Oh, God bless you, Mishigama. You're so wonderful. His funeral ends tonight into tomorrow. The stock market in the U.S. tomorrow closes at 4:30 Eastern. I will be live. If anything is going to happen tonight, I'll give you a few hours of coverage, but I need to recharge ahead of what's going to be a chaotic day tomorrow. Who knows what the hell is going to happen at this status conference / motion to compel. God only knows. We're going to watch it tomorrow in the afternoon. Then we will monitor what's going to happen in the Middle East. But for now, and you might get another stream from me today. But this is Pete Bunny Towel. Yes, there's an IRGC commander who has just been taken out. God bless you, AD4 DA Adam Deitch, all the way. God bless you, Sherry D, for watching, and Kevin from South Boston, great hanging with you. And Old Dog, it was so good to see you, dear friend. And Towel Girlfriend, you're wonderful. Towel Girlfriend Nikki is wonderful. Now, also hearing that one of the explosions caused one of the explosions in Avaz. So there were strikes, okay, and then an explosion, and there was a targeted assassination in the south of Iran. In Avaz, a giant 2-story building exploded due to a gas leak. Iran has also just released footage of their launch of missiles overnight. I'll show you that on the war update when we come back. You might get me again in like an hour for a couple hours on the war. But anyway, let me do this. This is Pete Bunny Towel. At the end of every stream, we like to check my mental acuity by reminding you that this is a public information service. We've been going for 4 hours and 20 minutes, almost exactly. How about them apples? If you'd like to support Towel News, which is designed to educate, inform, and entertain, 20% education, 20% entertainment to insulate your brain from trauma, 40% information, 40% education. There's ways to donate. Oh, thank you so much, Minx, for those jewels. I love that high five. You can do so via the Cash App, via the Venmo, or via the PayPal. Money sign Grant Smith Ellis on the Cash App, at Grant-E1 on the Venmo, and paypal.me/Grant Ellis. I'm going to go through and click like and try to reply to all the wonderful donations from today. Thank you all for being so kind. I'm going to go get some water, some snacks. You might see me again for war coverage, as I mentioned, in an hour. We also like to test my mental acuity regarding the end of these streams. It seems to be okay today, but I'm a little tired. These streams, of course, are designed to engender kosher public discourse, such as to ward off the usurpation of our forms of government worldwide. We like to do that by testing my mental acuity and listing the presidents in order. President Washington, President Adams, President Jefferson, President Madison, President Monroe, President Adams Jr., President Jackson, President Van Buren. Then 9, 10, 11 get a little tough. It's like William Henry Harrison. And then 11, 12 is like Tippecanoe and Tyler too. This is called Polk and then Taylor. 13 is 13 is Millard Fillmore. That's a tough one to get. And then it goes Pierce, Buchanan, Lincoln, Johnson, Grant, Rutherford B. Hayes, Garfield, Chester A. Arthur, Cleveland, Harrison, Cleveland, McKinley, Teddy Roosevelt, William Howard Taft, Woodrow Wilson, Harding, Coolidge, Hoover, FDR, Truman, Eisenhower, Kennedy, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama, Trump, Biden, Trump. How about them apples? I'll be back again, so we won't do our full outro. Consider a donation to our homeless vets or service members today, or our animals. This is our mascot, Pete Bunny Towel. Consider paying forward what you learned today, or the camaraderie and chat or otherwise, by donating to animal shelters if you can. Consider that. If you're in the UK, consider a donation to The Big Issue. Smile at someone on the street. Reach out to a friend or family member you haven't heard from in a while. Even give away 200 tomato plants like Francis Frutrell did one time. In turn, live up to these new standards of a realpolitik defined by, one, centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service and kindness rooted in unconditional love, and live up to your Tal, Eudaimonia, or Summum Bonum, your greatest good in the ancient Greek or Latin, respectively, and bring about a new digital epic defined by a towel, by Aquarius the water bearer, standing tall and carrying a Pete Bunny towel. Thank you for being you. Thank you for being with me. Towel News signing off for at least a little bit. It's 3:23 p.m. Eastern here, Thursday, July 9th, 2026. On Towel News, youtube.com/@GrantSmithEllis. It's 9:23 p.m. in South Africa, 10:23 p.m. in Tel Aviv, Israel, and 10:53 p.m. in Tehran, Iran. Back with you again very soon, hopefully, maybe, perhaps. Wishing you all well. Thank you for being you. Thank you for being with me. God bless the United States of America. God bless you all. Thank you so much for being here, and see you again very, very soon. Love your username. May the 4th be with you. And Minx, and Old Dog, and Standing Stones, and Written Dreams, and all of you, Mishigama, and Robin Hood, and Kevin from South Boston. See you all very soon. Signing off. Grant Smith Ellis.